have to adjust because
for Monday, my lord.
I'm not saying that let the court master adjust because there are many matters. So therefore, he'll have to adjust 1 or 2 days plus or minus.
My lord, for Monday. Oblige.
Yes.
So item 36, lordship, the government has filed affidavit in both IA and the main petition, lordship. I need to take some time for a reply.
Okay, 36.
36.
On the prayer made by Mr. B.P. Barar and counsel for the petitioner applicant, matter stands adjourned to enable him to obtain instructions on the affidavit in opposition filed by the state. List after
Lordship, 1 week.
list after week as before. Yes.
Well, I need to mention item number 55, my lord. In this matter, the respondent number main for we have filed a affidavit, my lord. So we'd like to file rejoinder to the affidavit. My lord. Item number 55.
Okay. Okay. Same order, Mr. M.R. Adhikari
Well.
for the petitioner.
Well,
Okay.
fixed date will be fixed, my lord. Because of this matter relates to, my lord, the petitioners have been rusticated from college money. So the exams are approaching.
Okay. Okay, 29th May.
Well, oblige.
Okay.
May I please your lordship?
Yes.
Lordship, I beg to mention item number 18, lordship. 18, lordship, my senior, the leading counsel, lordship, SNAF, lordship, he has some difficulty, lordship. Some person close one has expired yesterday evening, lordship. So I pray for accommodation only for 2 days.
Item 18.
Item 18 only for 2 days, lordship. May come.
Okay, you're taking consent of the other side.
I have
This is
yes.
Okay.
Department.
Yes.
Affidavit has not been filed, lordship.
Okay, on the prayer made by learned counsel for the petitioner. List after.
Lordship, only for 2 days. I pray for it only.
And it will come next week, lordship.
Next
Okay,
week.
list in the next week. Okay.
Oblige.
Yes.
May it be preserved. Lordship, I beg to mention item number 9, my lord. This case, my lord, I may be allowed to withdraw, file a fresh, my lord, because some clerical mistake has been occurred, my lord, that cannot be curable.
Okay. On the ground that there are some clerical error in the petition,
Item 9, no? 9.
Mr. R. Islam and counsel for the petitioner seeks to withdraw the petition and file again. Mr. SMD Cecilia and standing counsel for the school education department is present. Prayer is allowed. Matter stands dismissed on withdrawal with liberty as prayed for.
May I please, I beg to mention for listing, lordship, a content matter, lordship. Oblige, lordship.
Daily list item number 1, motion BA. Item number 1 for motion.
Lordship, in this matter, we have filed one additional evidence that is not on record, Lordship. I pray for list this matter on Wednesday, Lordship.
Okay. List on 24/5/2023 along with additional affidavit filed by the petitioner.
Oblige.
Please, my lord. This matter pertains to, my lord, inclusion of my name, my lord, in the pension book of the respondent number 6, who's my husband, my lord. So, my lord, notices will be required to be sent, my lord, to the private respondent, my lord.
Who are these respondent numbers 7, 6, 7, 8, and 9
My lord.
and 10? Who are they?
6 is my husband, my lord. And 7, 8, 9, and 10 are, my lord, they are the 7 is the second wife of my husband, my lord, and the rest are the children. One out of the very. Their names have been included in the nominee clause of my husband's service, my lord, pension book, my lord. Whereas I am entitled to as per the service rules.
But the person retired on 2011 itself, it's long back.
you see, you filed a 125 proceedings, correct? After the 125 proceedings was drawn up and you got an order, then you write a letter at page 34. And then you say, I got an order from the criminal court and therefore please include my name in the pension book. You can't be permitted to file the piecemeal litigation. You file for one relief, one today, tomorrow's another relief. You are hit by order to rule 2 CPC.
My lord, may I please take my lord to page number 38 for once?
30,
38,
38, yes.
that is annexure number 6. Lord. This is for the first time that I came to know about this particular, my lord, anomalies in the pension book, my lord, where my application to my reply to my RT application has been given to me.
That's more easy for me. You see this page 38
My lord,
is a letter of 14/5/2015.
my lord,
Your order in the FC criminal case is of 28/7/2016,
my lord,
after a year.
my lord. My lord, I have been filing several representations before the concerned authority.
I don't know, but it will be hit by the order to rule 2. If you omit to take a relief, then under whatever section 11, exception 4,
My lord,
explanation 4, a relief which was not claimed earlier can't be claimed in a subsequent litigation.
my lord, I have only come to know about this particular anomalies in these, my lord, book as of after giving me this particular application, my lord. Before, prior to that, in fact, there was no, my lord, I had no knowledge about this particular, my lord, that there is a anomaly in the pension book of his, my lord, and the name of the has been the other respondent has been included, my lord. And after coming to know about this, my lord, I have been filing several representations, my lord, which my lord will find at page number 41 also, the recent one, my lord. They have not been taking the respondent authorities have not been taking any action, my lord, which has constrained me to come before this honorable court, my lord.
It will definitely not take, because if the nominee is made by the husband
My lord,
and you don't challenge it then, because 2015 you are informed.
my lord,
Now we are in 23 after 8 years.
my lord. I have been filing representations, my lord.
I think of extension lawsuit.
On patches, I am not satisfied.
Yes.
And order section 11, explanation 4, in order to rule 2. I frame a question, you respond to it. We'll take it up whenever you want.
My lord, my lord.
When do you want?
But anyway, in the next week, my lord.
Who's the date? We'll fix it then. Avoid the Monday, Tuesdays and Thursdays. Take any date, we'll fix it then.
Third, my lord, if it's not inconvenient, Tuesday, my lord.
No, I said avoid Tuesdays and Thursdays.
Then, my lord, on Friday, my lord.
26th.
26th, my lord.
Okay. On the issue of delay and latches. Mr. R. Sensual and the counsel for the petitioner shall make his submissions on the next date. List on 26/5/2023. You also be prepared.
Yes.
Because it's a legal question again for you, Mr. Sisti.
Yes.
Because if the pension rules provide for the benefit for the first wife,
Yes.
can be only merely because of the delay and latches, can the petitioner be denied that remedy? That will be the question for you.
Yes.
Just add one thing. In view of the pension rules.
Yes.
Providing for pension to the first wife. For the Mr. SMT is standing also for the school education department shall also make a submission as to whether mere delay in approaching the court will prevent the petitioner from enforcing his legal right.
Yes.
This law 26.
This is execution, my lord, for direction to the SEBA, my lord, for correction of the one my admit card, my lord. My lord, kindly, I have passed in 1981, my lord. What happened, my lord, on the last vacation, my lord, I have come to know about it, not on my notice.
No, but you see, High Court can't enter into an adjudication. What is your date of birth?
My lord,
You have to approach the civil court, get a declaration, and then approach the.
my lord, these are recorded, my lord, only some mistake because by the SEBA done, my lord. Kindly turn to page, my lord, page 22, my lord. What happened, my lord? I was the candidate of 1980, my lord. Because of Assam agitation, my lord, the examination was cancelled, my lord. And the next year, exactly, it was happened. Exactly difference of 365 days, my lord, 1 year, my lord. They have filled up the form. From the school, it is done rightly, my lord. I have checked the school documents, my lord. And principal has also issued a document in this connection. That exactly difference of they have filled up in 81, but they have said in 80, my lord. There is a difference, mistake committed by the SEBA, my lord. And my lord, kindly see page 23 and my lord 24, my lord. This is my lord test certificate from my ME school to high school, my lord. Exactly, my lord. There are
You see,
differences,
there are
1 year,
many difficulties, Mr. Talakdar.
my lord.
I don't expect this SEBA to maintain the records of 1977.
My lord, on the other day, my lord, learned friend was saying that yes, they have maintained on the basis of what they have maintained on the other court. I was hearing, my lord, and also on the basis of that, my lord, the honorable court was.
Yes, you maintain
please to
record
come in
of
order, my
27.
lord.
My lord, the date of birth is recorded on the basis of statement provided by the school authority at the time of appearing in the HLC examination. And accordingly, his date of birth recorded, my lord. There is no error in recording.
Your original record.
Yes, ma'am.
You revert on the next date.
Yes, ma'am.
Lordship, one thing, Lordship, sorry, Lordship, one thing that it says it will be secondary education, Lordship. I think it's not higher, Lordship. It's a high madrasa.
High school, my lord. SEBA, my lord.
Education, Lordship.
Matriculation, my lord.
Yeah, correct.
Okay. No, then you have to amend your cost title. This is Director of Higher Education.
My lord, this is made for my lord for correction in other document if required. Well, that's why he working in high school, which is controlled by higher authority, my lord, higher secondary. That's why, my lord. But correction is only in the respect of my lord HSLC.
No, against respondent 2, you are not claiming any relief.
My lord, the respondent 4, my lord, is perhaps the right respondent, my lord.
So we strike out number 2,
So
Maybe,
number
maybe,
number
maybe,
3,
yes,
Lordship, they are not.
Yes,
2 and 3.
Inspector school also.
It
Nothing to do in this case.
is not required.
He said
Okay.
EEO.
my lord, 4 and 5, my lord.
Or Mr. A. Kitabagal and counsel for the petitioner. Mr. SMT is still under counsel appearing for the, Mr. S. Mian Leonard, standing counsel for the Higher Education Department, submits that the Director of Higher Education has no role to play in the issue relating to correction of birth in the certificate issued by the SEBA. Similarly, Mr. SMT is still under standing counsel for the School Education Department, also submits that respondent number 3, Inspector of Schools, is also not the authority concerned with the prayer made in the writ petition. So accordingly, without disturbing the seriatim of the parties, the name of respondent number 2 and 3 are struck off. Next one. The petitioner claims that although a correct declaration was given of his date of birth, but in the school living certificate issued by the
The admit card also.
An admit card issued by the Board of Secondary Education Assam, comma, incorrect date of birth. Was recorded showing the petitioner as 16 years, 6 months, 1 days. First of all, the petitioner claims that his date of birth
Exactly 1 year before.
was, where is the date of birth?
My lord, actually, my lord, on those things, my lord, earlier, my lord, there was no system of recording date of birth, only years and so on, my lord. But exactly 1 year, 1-3, that is the exactly 1 year difference. 365 days.
Okay, but as per administrative register, in class 8, the age of the petitioner was, as on 29/4/1977, was recorded as 12 years, 7 months, 29 days.
That is the correct, my lord.
Full stop.
My lord, only kindly, maybe recorded, my lord, the page 23, my lord. This is temporary certificate.
No, that's what I have recorded. Have I made an error? No, I don't think so.
My lord, your lordship reported perhaps page 22, my lord, Annexure C, my lord, this high school, there is a principal issued by principal, my lord.
You come to page 6. Come to about 10 or 12 lines from below. Here you have made a mention that admission register in class was 12 years, 7 months, 29 days as on 29/4/1977.
Yes, my lord, correct.
Then what wrong I have committed? So accordingly, next one, Mr. D.K. Roy, and standing counsel for the Seva, has submitted that that on the basis of information provided by the concerned school, comma, entries of date of birth was made by the Board of Secondary Education Assam. And that the said authority is not responsible if incorrect information is provided by the school concerned.
Yes.
That's for be the resignation. Issue notice returnable on
Let's short date my candidate.
9/6/2023. Requisite extra copies of the rate petition be provided to the learned standing counsel for Department of Public Standing Counsel for respondent numbers 1, 4, 1 and 4. Petition shall take steps within 2 days for service of notice on the respondent numbers 5 and 6 by registered post with AD, and in addition by Dasti by routing the process through the registry of the court. And upon service, an affidavit of service shall be filed prior to the next date of listing. Next paragraph, or on the next date of listing, the learned standing counsel for the secondary education, Seva, shall produce a true copy of the relevant extract of the
Yes,
register maintained.
MRS, my lord. Monoscript register sheet, my lord.
Okay. Monoscape
Monoscript, register
or
sheet.
manuscript.
Manuscript.
Manuscript
Register
Register sheet.
sheet.
within bracket MRS for short. Okay.
Oblige.
On
May the lordship may kindly pass over the matter for time being. Senior is in lakhs in court one lordship.
Okay, but it will be taken up in the, sorry, revision is there. Okay. Mrs. Zekia, you tell us your convenient time. You take it up then.
Maybe there's another item 7 or 8.
Eight
Along with it.
Okay.
Deputy.
May I please, lordship, item number 5, conducting counsel is on legs on another court, lordship. So please kindly adjourn the matter for time being.
Okay, we'll call in the, it will taken up in the second call. See, I don't know to buy it. It was in the.
6.
Yes, Mr. Arvind.
But the petitioners, my lord, they belong to my lord OBC, my lord, and they appeared in the test for admission in class 9, my lord, in Jawaharlal Navodaya Vidyalaya, my lord. They were selected, my lord, for the admission, but their admission is not given on the ground, my lord. Their OBC certificate is not countersigned by the deputy commissioner.
Where is your OBC certificate?
My father's certificate, my lord, page 18.
Page 18.
Lord.
Okay, yes.
And our petitioner certificate, my lord, page 20, 24 and 25, my lord. Two petitioners, my lord.
Yeah, but this, they are otherwise right. Without the counter signature of the
Lord.
deputy commissioner, they can't accept this
It
certificate.
was forwarded to the deputy commissioner. He has not signed, my counter signed. In the meantime, my lord, admission process has been started. So similarly, case arose before this all court, my lord, and this all court pass interim order, my lord. I have annexed, my lord, page 50. One case was disposed of. I have also annexed, my lord, case 45.
Who's appearing for this? This backward classes, Mr. Ardhar.
Lordship.
You just try to find him. Mr. Dhar, try to find him. Because in his absence, you will not be inclined to pass an order.
Okay, also not start with him probably.
Huh?
Government
Ardhar,
also appear, my lord.
not been
Government
shown
is
his
there.
name. Mr. Ardhar appears in WPT department, my lord.
Yes.
His name is not shown in the court list also.
Oh, that's why he search for him. No, copies were not served.
Okay, was served upon government, my lord.
No, but without him, we can't pass an order like this. As part order,
I will inform him and
as part order will
Lot.
can be passed. This does not even have a what do you call this acknowledgement.
But it's a officer of fund.
Just
Yes, I don't know, I'm just over here. That's over and I.
it is being served only to one government advocate and DSGI.
CGC.
DSGI. Oh, okay, try to find him.
Lot.
Yes.
Yeah, please. My lord, in this case, my lord, let's kindly have a look page, my lord.
Oh, just a moment. To all the learned counsel, before I take up the brief in admission and order matters, please check the files because I am finding it very disturbing that lawyers do not assist the court making the correct submission as to whether a service report is there or not.
Yes.
Those things I'll be stopping doing Laozima. I'll pass adverse orders. So any learned counsel, they may come to the court master, look at the brief, because if I find that I'm not being getting the requisite information by the lawyers, I'll be passing adverse orders. So yesterday, I took up a matter, and then when I read the file, I find the service deposit not complete. So those things, I am spending my time unnecessarily. It is better to pass adverse orders against the council than spend my own time. So from today onwards, I'll be harsh. It's just not palatable that nobody would assist the court, as if the court is to do the clerical work.
Yes.
So learned council will take note. I'll pass adverse orders. If things like service report is not available and you don't inform me,
Anyway.
yes,
My lord, page 114, my lord, annexure 1 is my lord, initial order to hold the my lord, the post of headmaster my lord, in the LP school and secretary of the managing committee, my lord. When I am working, my lord, some fund.
your school is a provisional school.
Provincial school, my lord. Then, my lord, suddenly, my lord, order came, my lord, page 16. As per this order, my lord, block elementary education officer directed me to hand over, my lord, charge to one junior Mokhlisur Rahman Majumdar, my lord. Then, following this order, my lord, another order was passed, my lord, page 18, annexure 3. My lord, this order was again reiterated by the, my lord, district elementary education officer to hand over charge of, my lord, secretary and headmaster to the my lord, junior, my lord, Mokhlisur Rahman, my lord, Majumdar, my lord. Accordingly, my lord, I handed over the charge. In the, my lord, they conspired the matter, my lord, and with the some false, my lord, complaint and my lord, reports, etc. My lord, page 21, I was placed under suspension, my lord. This is by the district elementary education officer. My lord, last two line paragraphs, my lord, small paragraph. Hence, the undersigned is pleased to place Abdul Jalil Majumdar under suspension pending dual of the departmental proceeding with immediate effect. During the period of suspension, my lord, he will be allowed to draw 50%, my lord. And this order was passed on, my lord, 2nd July 2022, my lord. In the meantime, my lord, I approached before this honorable court, my lord, page 22, my lord. And here, my lord, this honorable court was pleased to, my lord, vacate the suspension order, my lord, and he was provided to reinstate me to my original post as, my lord, assistant teacher, my lord. Then, my lord, but till today, my lord, I am not, my lord, released other, my lord, 50% of my salary, my lord. And I am, my lord, also not taken up as, my lord, the headmaster of the school, my lord. This is my lord, prime grievance before your lord.
Subsistence allowance will have to pay.
My lord, we'll pay, my lord. My lord, today, my lord, notice me go. I'll get my instructions, my lord, as to why it has not been paid. They actually, my lord, this post is a post of head pandit, my lord. Lordship, please, my lord, I have to get my instructions, my lord.
It's okay, but in the meantime, if his subsistence allowance not been paid, that must be released.
My lord. That may be given, my lord, and
That inquiry can be made and it will be released. But Mr. A.M. Borbojal and counsel for the petitioner. And Mr. A. Sukandar, standing counsel for the school education department,
correspondence, my lord,
appearing for respondent numbers
1, 2, 3, 4,
5,
and 5, my lord.
1 to 5.
1 to 5.
Next paragraph.
Subsistence allowance, my lord,
the-
50% paid, my lord. My lord, 50% paid, my lord, as per the suspension order. But I am paying, my lord, the rest, my lord, 50%, my lord, which is not paid.
Rest will not be entitled to unless the departmental proceeding is ended.
My lord, then, my lord, 50% to 75%, it is also not paid.
That is why, my lord, let me get my instructions, my lord. He's not clear himself, my lord.
The case of the petitioner is that he was the assistant teacher in
Number,
Lair number 2231 HINGLAIR Lower Primary School, Hailakandi. And he was given the charge of headmaster of the said school. So however, he was asked to hand over the charge of headmaster to another incumbent. And thereafter the petitioner was suspended. And against the order of suspension, the petitioner approached this court by filing WPC 7922 of 2022. And this court by order dated 6/1/2023 reinstated the ordered reinstatement of the petitioner. And according to the petitioner, was restored to his position as assistant teacher of the concerned school. First one. By order dated 15/2/2023 passed in Contest C 74 of 2023. Direction was issued to comply with the order dated 6/1/2023. Referred above. Within 1 month from the said date. And the contempt petition was closed. Post it is submitted that after the petitioner was reinstated to his original post. And the grievance of the petitioner is that he has not been given the charge of the headmaster, sorry, head teacher of the said school. Head teacher or headmaster?
Head teacher, my
Head
Teacher of the said school. And that is balance subsistence allowance.
Actually, it is my lord head pandit,
Head pandit.
head pandit actually,
Okay, make it head pandit.
according to 1981 rules.
Okay. It is claimed that although 50% of the subsistence allowance was paid, covered the incremental amount of subsistence allowance to the extent of 75% from the relevant date was not paid. What is this 40,000 rupees?
40,000, my lord, he, my lord, spent for, my lord, midday meal, my lord, when he was working as headmaster, my lord.
Where is your authorization to make that payment? Where is your authorization to make that payment?
My lord, because this is the practice, my lord, at first, my lord, manage headmaster, my lord, subsequently they pay, my lord. All over Assam, my lord, he instructed me, my lord.
There is no proof that he spent that money. There's no, he's not annexed anything, my lord. He spent that
Yeah.
money, my lord.
Spend, my lord, one annexure, my lord, page 19, lord, you kindly have a look,
Page 19.
page 19, my lord. And it is received by the, my lord, incoming, my lord, headmaster, my lord. Moklisul, my lord, from me, my lord.
This is my lord a normal type copy, my lord. And also the
Petition also claims that he received a sum of rupees 40,147.54 allegedly spent by him for midday meals. Next paragraph. Issue notice returnable on so and so. Requisite extra copies of the writ petition be served on the London Standing Council for the School Education Department in course of the day. Next paragraph. The pendency of the writ petition shall not be a bar for the concerned authorities in the School Education Department to ascertain as to whether any subsistence allowance is due to be paid to the petitioner. And if so, to release the same. You should notice returnable answer also.
4 weeks.
But that are what we said, no? 4 weeks. List accordingly out of 4 weeks.
11.
Wait, please, Lord.
Just a minute. Yes, Mr. Decker.
So over here, also the grievance of the petitioner number 1 is there. Although his service is provincialized as tutor lordship, but his services ought to be provincialized as a head teacher of the school as per the norms and standard prescribed by the RT Act lordship.
Second, only if you notice at this stage.
And so for the petition number 2 lordship, as per section 311 and 312, since the number of enrollment of students is more than 100, therefore, 1 additional post should be sanctioned lordship, as per the section 311 and 312 of the 2007.
That you have to, we will hear it some other day. But you see, that is not mandatory that for addition of students, there has to be mandatorily additional teachers. It's
So this is as per the lordship, kindly, I have posted those lordship section, but so kindly come to page 13. Page 13. This is the RT under section 19 and 25. This is the norms and standard. Then section 311 may read at page 14. In case of Dhansar Upper Primary School, there shall be minimum 3 teachers or tutors, at least 1 teacher each for provided. For additional posts, it shall be considered in accordance with norms and standards stipulated in the schedule under the section 19 and 25 the RT Act. Now, the RT Act, the Provincialization Act of 2017, they following this section 19 and 25, they have given this 3 number of teachers. But provided they also given if the number of students exceed 100, then 1 additional post will be sanctioned. That is why this petition number 2, his services also to be provincialized under this section 2017 Act.
But then if the 2 people are different relief, why join them in a risk?
Because in the petition number 1, his service is now provisioned as a tutor. Actually, this post is supposed to be for the petition number 2. Now, actually, instead of provincializing the service of the petitioner number 1 as head teacher lordship, as per this RT norms of under section 19 and 25, the petition number 2 is deprived. So both their rights are also interrelated.
Lordship, at this stage, notice may go, my lord. I'll get my instructions and I'll file a detailed affidavit.
Lordship, if I come to the, I have ended the DIAS report, Lordship, from 2006 onwards.
No, that's
up to
okay.
2022.
That's okay. We are issuing a notice.
Lordship.
Issuing a notice. What we say, head color and counsel for the petitioners. And Mr. A. Fukan Leonard, standing counsel for the School Education Department.
It's 1 to 4.
Appearing for respondent numbers 1 to 4. And for Deputy Commissioner, Mr. Sekhar will appear.
It's 1 to 5.
Mr. P. Sekhar and Government Advocate appears for respondent number 5. Next one. We issue notice of motion written number 1 in 4 weeks. Requisite extra copies of the writ petition be served on the Government Advocate and the Learning Department Council in course of the day. In view of the nature of claim made by the respondent numbers, the petitioner numbers 1 and 2. Report expects the School Education Department to file their response timely. List after 4 weeks.
In the meantime, they will just respond, they will file a affidavit lodging.
That's what I've said.
A lot. Biplab.
Well,
Lordship, I'm on behalf of petitioner. My senior is out of station. So kindly seeking for an adjournment for the.
Just a moment. Do you know what is the case?
Yes.
What is it?
I have not gone through. Sir.
You've not gone through. You know this, what you call, what would be the a very pleasing term, I don't know, but there's a English term called animal instinct. You know that when a animal of any nature is born, except for mammals, they translate themselves into wildlife. You've seen that survival instinct is there. You noticed, except for mammals, others are not normally dependent on their mothers. Correct. So we'll take it up at 2 o'clock. Even if your senior is absent, have that instinct, read the brief and tell us what the matter is about. Even for the purpose of an adjournment, I'd like to hear you. Right? You'll have to learn how to swim. Correct? At 2 o'clock.
May I please, Lordship, item number 13. Lordship, conducting counsel is on legs on another court actually. So Lordship kindly adjourn the matter for time being.
In this is, they are basically against the amalgamation of the school, Lordship.
I have seen that.
Already there is an amalgamation and merger review
Let
committee is there.
us senior be there. I've seen that.
14.
Yes, Mr. Bala.
The basic question here is, but we have appeared in an advertisement for the post of LP school teacher. Total number of marks I have obtained is 210. That is, the cutoff is 204, but still my name has not been included. Now, Lordship would see the advertisement.
How many posts are advertised?
Yes, Lordship. Lordship would see at page 17.
Yes, how many? Just tell me how many posts are advertised.
It's post exact number of posts is not
Lordship,
given at
in the
page
first
17.
title, Lordship, it is shown as higher, Lordship. But they
3887.
already
3887 post.
Okay, and what is the last what you call candidate indicated here? At what is the serial number?
I applied for Kamrup Metro, and therefore I have annexed a second provisional list at page 26.
In Kamrup Metro, how many vacancies are there?
Lordship, at page 26 is the last 204.
No, you see, I'm just trying to ask you. Supposing the in a college admission, the cutoff marks for admission is, say, let us say 98%. I get 98.2. Correct. But by the time 100% and this 99% are in queue, so the seats are filled up. And therefore, the name is not published for the purpose of the admission because the seats are filled up. So you see, it's a cutoff mark, but it may not be still in the list if the list is more than the what you call the vacancies, unless you can show that the as per the this rules of admission, there's a requirement that there should be X number of persons in the list. Say vacancies are 100, the list should contain twice the number.
Yes, yes.
So are those type of criteria here?
Lordship, no, Lordship would see page 23 for once. The district-wise vacancies are not given in the advertisement. Therefore,
Okay.
the only criteria for
But
selection is
you have to
page
still amend
23.
it. Higher secondary is not the concerned authority here. That's what.
Lordship, higher education, some already made party, Lordship.
They are not involved.
You know how.
Yes.
We'll strike out their names then.
Lordship, high secondary is involved because there was a scheme under which we passed the
Yes.
high secondary. Therefore,
higher
high
education.
secondary is a necessary party.
Why?
Lordship, at page 30, Lordship would see.
First of all, where is that advertisement?
Page
That is page
17.
17. Is the elementary.
Yes, yes.
Then what will they do in this
Lordship,
matter?
Lordship, the marks to be calculated is HCS plus state plus DLA. Now HCS,
No, but these people can't be joined. You see, let us say that that a man is required to be a graduate to fill up a post. He passed his nursery, he's passed his preschool, he passed his metric. Should all the authorities be made a party here? Necessary parties should be there.
yes, of course, Lordship, this is a proper
But
party.
then how?
Lordship, because we had passed the high secondary,
Anybody is challenging that?
no.
Then
Therefore, just for information,
no. They don't need information. They know that they have their certificate.
Hired, Lordship, this is elementary, I mean, higher secondary,
it is
higher
not
secondary. In
Lordship is strike with
higher secondary, I think.
No.
No,
If
no
you
higher, not higher.
if you challenge my what you call my whether X is metric passed, you can't repeat the school,
The higher
preschool or kindergarten.
Higher
Just for that. Heard Mr. B.P. Ward and counsel for the petitioner. And Mr. P. Barwar and
As well as.
no, his name, I'll come you to that.
I am for
Rather counsel for school education department appearing for respondent numbers
2, 3,
2, 3,
2 and 3, my lord.
2 and 3.
My lord.
Uh,
One is higher education.
1 and 4, Lordship, to strike down.
3. Mr. You are for?
Respondent number 6 on behalf of everyone.
Okay, then Mr. S. Bhuyar and standing counsel for
Higher
higher education department representing respondent number 1,
and 4.
1 and 4. Miss
P. Tamuri,
P. Tamari for respondent number
6.
6. Then who's for 7?
Some higher secondary education council, my lord. Standing council is there, my lord.
Who?
T Shutia, my lord.
Okay. Mr. Teacher there for respondent number 7.
Council.
Next paragraph. As
My lord, I'm sorry, my lord. Council, my lord, there is no standing council. Notice has to go, my lord.
oh, okay, 7 is not required. It is observed that no relief is claimed against the higher education department. And therefore, the court is inclined to strike out inclined to hold that the higher secondary, higher education department is not a necessary party in this big petition. And therefore, the names of respondent number 1 and 4 are struck off without disturbing the seriatim of respondents. Next paragraph. On the ground that the petitioner has secured more than the cutoff marks, but in the district-wide select list, i.e. provisional and final This provisional and final.
Second provisional.
Ajay, the first and second provisional list, the name of the petitioner does not appear.
Second is final. Second may be the final because 25th is the.
Okay, it's okay. Whatever you say, you said second provisional, so I recorded second provisional. And accordingly, the select list is assigned by the petitioner with a prayer to appoint the petitioner in the sanctioned vacant post. Next, issue notice returnable on so and so, or it's the petitioner shall takes so requisite extra copies of the petition to the learned departmental counsel in course of the day. Next para, the petitioner shall take steps within 2 days for service of notice on respondent number 7 by registered post with AD. And thereafter collect the postal receipt number and submit a postal track report to the registry prior to the next date of listing. You- Till the next returnable date. Comma. One post off.
No, my lord, here, my lord, our name has not been shown, my lord. Kindly see the clause list, my lord. Our name has not been shown, my lord, only SC higher division.
No, that's okay, but you don't have,
My lord, let us bring the instruction, no, my lord, not. My lord,
but if you fill up the post, then no, because you see, till the next day you can't appoint anyone who's below him. That protection I have to give him.
my lord, sort that may fix, I'll.
No,
bring
you
the-
see, if he secured, say, let us say he secured 60%, you can't appoint somebody with 55%.
No, my lord, it will open a floodgate, man, kindly, man. Let us
Lordship,
bring
we
the-
couldn't go through the record yesterday, Lordship, because our name was not shown in this call list, and it was also not submitted to us, Lordship.
Then we'll take it up on Monday, but.
Yes,
uh,
yes,
My
yes,
lord, my lord, yes.
He's entitled to a interim.
We'll take it up on Monday.
Our name may be shown in the clause list.
Because you see, if he's challenging that his name is ousted, then you can't appoint somebody who is below him.
On Monday, my
That-
lord, our
That's
name
the amount
may
of
be shown.
protection he was, will be getting.
On Monday,
Okay.
our name may be shown in the code.
Don't type that. The registry shall reflect the name of SC elementary education while listing the matter next. School education it will be,
My lord, SC elementary education will be enough.
sir. Elementary education. List on Monday.
22.
Bless, man.
And you also take an instruction because
Well-
if his name is not there, then he's entitled to a protection.
My lord, I'll
You,
bring
you
this.
can't appoint somebody who's below him. Then there will be again a lot of litigations.
I'll try to bring instruction on Monday.
Hmm.
Bless.
And so far as Mr. Chisti said about the floodgate,
Yes,
we will not be offended by that. Correct?
15.
Make legal lawsuits. Petitioner before your lordship is a headmaster in the school of, my lord, Hamaji Scheduled Caste, Raspberry, ME School, my lord.
You can issue a notice in this matter,
Yes,
not do anything more.
let them bring instruction because your lordship kindly peruse the last
Stay legal and
election.
counsel for the petitioner. And Mr. A. Fugan and the standing counsel for the
It's
school
got 1 to
education
5.
department.
1
Appearing
to 5.
correspondent number is 1 to 5.
And 6, my lord, is 6, my lord.
Uh,
Mr. Decker, Mr. Decker.
And
Yes,
Mr.
yeah.
P. Sekal and government educator
Yeah,
appears
still
correspondent
alive.
6. Next paragraph.
Notice in the-
Agree by the non-provincialization of the school of the petitioner. The present petition is in filed under Article 226 of the Constitution of India. issue notice returnable on so and so.
4 weeks.
Requisite extra copies of the restriction be served on the learned state and department council in course of the day. Next paragraph. The pendency of this representation shall not be a bar for the respondent authorities to examine the claim of the petitioner and take steps in accordance with law. List up for 4 weeks.
The date may be fixed. Under the
Date fixing is very, very difficult. You make a mention.
Yes, yes. Well, you're blessed.
16.
You see, Mrs. Devi. Since I'm taking this bench, I've requested the registry to list, to make the list manageable. Correct. And more than 75% cases are being adjourned. Although the matters before me are 2019 and earlier.
Yes, yes. Thank you. Thank you, sir.
Except for 3 cases in part 2, nobody has turned up to do their cases. 4 or 5 lawyers are continuously present, but their matters are adjourned because the other side lawyer is not there.
Yes.
So except for 3 matters in the part 2 list, I have not been able to touch anyone. Even for 14 and 15 matters, adjournment prayer for adjournments are made. So therefore, you see, please understand the difficulty. I am listing the cases and those matters are being adjourned, and the lawyers who are eagerly waiting to do their cases
Yes,
can't be
sir.
listed.
Yes.
So, I think you have to be harsh. If people are not coming in part 2, if you see 2014 matters, I have to
Yes.
adjourn. Just think the.
Hello.
Yes, next item is item 16. We are issuing a notice, in fact, interim I don't find will be
The,
amalgamation on challenge can be interfered at this stage.
what they have also prayed in the synopsis, they have said, there's a similar case where they have been directed to file an appeal before the department. There's a provision of an appeal. They have not explored that as of yet. And they want to state in the disposal of the appeal.
So that's why I'm saying I'm not interested in the stay at this moment. None appears on call for the petitioner. How Mr. Muzumdar and his study council for the school education department is present. In this repetition, it is projected that the petitioner has preferred an appeal. In respect of the order of amalgamation of the concerned school. And the petitioner is seeking a direction upon the respondent number 1 to dispose of the appeal. And it is stated that till the disposal of appeal, the order of amalgamation should be maybe be suspended. Next paragraph. If you notice a motion returnable on so and so.
4 weeks.
Requisite extra copies of the Mr. R. Mazumdar accepts notice on behalf of respondent numbers 1 to 5, 7, 8, and 9. Mr. P. Saikar and government advocate accepts notice for respondent number 6. 5 and 6 are you. Okay, 5 and 6. Therefore, exclude them. 5 and 6. Then 6 by section. Requisite extra copies of the petition be served on them within 2 days. Next paragraph. The petitioner shall take steps within 2 days for service of notice on respondent numbers 10 and 11 by registered post PPD. The petitioner shall collect the counsel for the petitioner shall shall obtain the postal receipt number and submit postal track report prior to the next date of listing. Next paragraph, the pendency of the writ petition shall not be a bar for the respondent number one. So,
That is what I was trying to point out. Respondent number 1 and 2.
yes,
Made it the Commissioner Secretary, Government of Assam Secondary Education Department and Government of Assam Elementary Education Department. These
Yes.
posts are no longer there. It has to be to the Secretary of School Education. And the appeal is also to the Commissioner Secretary, Government of Assam Secondary Education Department.
Acha.
It has to be, they have to correct the memo parties and the appeal has to be addressed to the proper party.
Oh, then I cannot,
That will be-
also cannot issue notice there.
Yes, but that is.
But then don't write that. None appears on call for the petitioner. Mr. R. Majumdar and his standing counsel for the school education department has submitted that there is a reshuffle of the education department, the school education department, and there's no
Two education.
office under the nomenclature given for respondent number 1 and 2. So he submits that now the school education department is headed by
Secretary.
secretary to the government of Assam. So hence it is submitted that not only the cost title of this writ petition is required to be amended, but the appeal filed by the petitioner against the provincialization also requires an amendment. Next, with the resignation as the petitioner is absent on call. List on 24/5/2023. In the meanwhile, the counsel for the petitioner shall take a call on the submissions made by the standing counsel for the school education department.
Foundation.
51.
Yeah, please. 51, my lord, if it could be after some time, Mr. Chisti is just taking the,
Okay, after some time.
perhaps, the AG would like to appear, my lord. If it doesn't
Please
appear,
confirm.
Take it up after some time.
Just tell the time, Mr. Bhattaku is a busy man.
No.
Just after some time.
Okay.
Anytime.
Seven.
Okay, item 7 on the prayer made by the counsel for the petition matter stands adjourned today. List.
Next.
Item 2 is.
Piece of paper.
This SMTCC counsel for the school education department is present.
For admission 17.
and we are trying to trace out the record. Last revision lordship has given us some time. My lord, could have it after a week, my lord. Because now we are, the entire department is engaged in the appointment process, my lord, those. We have get for appointment, my lord, proper process have not been declared. I need a week more, my lord. 24th is the appointment date, the day after I can have it up. Maybe on 26th, my lord, I'll have the records.
Because this is
If it is
20,
traceable.
because it is 2017 matter. We can't
Yes, my lord. The
keep on
madrasa,
adjourning it.
it related to the madrasa education.
Yes.
Now it is with the secondary education, my lord, the entire
No,
department.
we
is-
remember your submission. But
I had made a
Sir.
request.
Parvati would be in a difficult situation if matter gets delayed.
On the 26th, my lord, just a
26th.
week, my lord. 24th, the process is over, 26th, I can make an effort to have it done. 24th, the appointment process is over, 26th, I'll have it.
24th.
5th and
Then these
26th,
people will relax and then do the work. We'll mix it on 29 then.
29, my lord.
We don't need an adjournment. Mr. S. Kodagil and counsel for the petitioner is present. The petitioners is present. Mr. R. Mazumdar and standing counsel for the school education department has submitted that the concerned officials are engaged in the appointment process which would end on 24/5/2023. It is also submitted that as the records which were then available with the Directorate of Madrasa, Director of Madrasa Education, could not be tested out as this, and in the meanwhile, the said directorate has been merged with the Directorate of Secondary Education assigned. Next paragraph. In this next paragraph, in this case, the case of the petitioners is that process was issued by the initiative for regularization of services of the petitioners. For which funds, for which funds were received from the central government. And therefore the petitioner, the prayer of the petitioners is that the process be completed. Next, therefore, the respondent authorities shall take note of the fact that the matter is pending since 2017 and take all steps for providing the relevant instructions to the Advanced Standing Council, within which the matter would be heard on the basis of materials available on record. List on 29/5/2023. Mr. Mazumdar, you always have an alternative steps taken. You see, the case of the petition is that it was funded by the central government. If the funds have come, so they can always find out the utilization. There will always be a utilization certificate with the authorities, and that will always remain on record. So if that utilization certificate has not been issued, that means funds are available and parked with the state government for that purpose. So why it should not be completed?
Well, the funds.
Or you can also show alternatively that the funds which were parked were always returned, and therefore this
We
is,
returned.
the utilization was not made. Therefore, this state petition would not be entertainable. So even if the records are not there, alternatively also it can be always ascertained.
I have asked them to come up with whatever reply they can on this issue. I
No,
have
you
suggested
make
this.
them a suggestion because this is something which related to accounts. It may not occur to them.
But this infraction was there on the last day also.
Oh, you
Therefore,
did
I have
Oh, you have
done
done
it,
that
yes,
actually.
yes.
Okay.
either
Because-
the utilization certificate or the returning of the money, that the money has gone back.
Huh.
Either of the two I have to bring on spirit on record.
Huh.
Yes.
And Mr. Kotak, I just, since I did not examine the cost titles, you're in your prayer, you are saying about the petitioner association. How does this prayer come?
We are individual as well as association, unregistered registration. Because it's as a whole. Okay.
But that would be opening up a Pandora's box. We can't.
Well, that may be, the other persons are there.
It's okay, just remind me on the because I was just thinking when I was reading your
Okay,
prayer, then
I will also do.
Yeah. Okay.
Obliged.
Yes, the Advocate General is here. So what is, which matter?
3 matters were there, Lordship.
Okay, since you have precedence of.
I can.
51.
Which item?
51.
Yeah, just a moment, let me get the records. Just a moment.
Lordship.
Yes,
So, Your Lordship, there is a school called Remote Town High School, Your Lordship, at Shivsagar district, Remote Town, Your Lordship. Now, this has been functioning for long, Your Lordship, since the year 1988, Your Lordship, and in the 73, Your Lordship, and in the year 1995, Your Lordship, this school was provincialized, Your Lordship, by the government of Assam, and since then, they have been functioning, Your Lordship, around 100 and more than 100 students are there, Your Lordship. Now, while the school is functioning, this academic session also started, Your Lordship. And in the meanwhile, Your Lordship, there is a first we came to know about a decision, Your Lordship, that through social media, Your Lordship, a letter was circulated on behalf of the, Your Lordship, the chairman of Adarsa Vidyalaya Sangathan, which says that another model school, Your Lordship, was sought to be established in the same campus, Your Lordship, same campus of the present school, Your Lordship. Now, this was never been communicated to the school authorities, Your Lordship. They were not aware about this, Your
school is a
Lordship.
provincial school.
Provincial high school, Your Lordship. Then, Your Lordship, what has happened, Your Lordship? Thereafter, some meetings also taken place, Your Lordship. Then, Your Lordship may kindly come to page 37.
Yes,
Now, Your Lordship will find, Your Lordship, this with reference to the subject cited above. This is the principle. In fact, Your Lordship, this has been sent to us through WhatsApp, Your Lordship, with reference to the subject cited above and letter received from MD Adarsa Vidyalaya Sangathan Assam. 3 number of schools proposed for Adarsa Vidyalaya by Honorable MLA of Mahmora Amguri Thaura. We are, Your Lordship, concerned with the Thaura, Your Lordship. Remote town HS Thaura. Now they know to facilitate the operationalization of the Adarsa, it is decided to amalgamate merger upgradation with school with the nearest schools. Therefore, we are requested to submit following. And thereafter, Your Lordship, this has created certain confusions, Your Lordship. This is because, Your Lordship, first of all, Your Lordship, we are not against, I would have to submit, Your Lordship, the establishment of a model school, Your Lordship, under CBSE curriculum, Your Lordship, that can government always do, Your Lordship. And if government feels, Your Lordship, it is in the realm of their power, Your Lordship, to amalgamate everything. But what has happened, Your Lordship, in the midst of an academic session, Your Lordship, they have taken a decision, and for the last annexure, Your Lordship, will find that they are asking us to vacate 6 rooms, Your Lordship, without deciding where we will go, where the teachers will go, where the students will go, the entire decision-making process, Your Lordship, by which this decision has been. First of all, Your Lordship, the question comes, Your Lordship, why this school has been selected? That too at the instance of an MLA, Your Lordship. Without any other authority concerned, Your Lordship, the education department.
He is a public representative. He has a right
Maybe,
to.
Your Lordship. But
Right.
there will have to be an exercise, Your Lordship, how he has conducted, how he has identified that particular school, Your Lordship. And Your Lordship, the hasty manner in which this entire process is going on, Your Lordship will kindly come to page
Mr.
42.
Just a minute, Mr. Bhattakur.
Lordship.
You see, no government in its rights, what do you call in right thinking process would disturb the student's academic career. Correct. Because once education
Ideally, that should not be, Your Lordship.
education has the session has started, that session can't be disturbed.
Lordship.
That is one. But if it's a government institution, the government has a right to take a policy decision in respect of that school.
No, that I at the very first instance, Your Lordship, I have admitted that, Your Lordship.
So you see, the only problem would be if I can think aloud, or if I am permitted to think aloud,
Lordship
is that you see, it's only the members of the that school committees who would be disturbed, except for their disturbance of their status. It's not the students who will face any difficulty, because I think even the education will not say that the classes would be disturbed.
No, absolutely not. It is upgradation of the school, and there's a lot of public demand.
No, it's okay.
Upgrade
That's-
this-
Lordship, I am not on
No,
the.
I'm only on one question. I hear you.
Yes.
Only on one question I was there. Whether the academic session of the.
Absolutely not. If Lordship is pleased to come to page 42.
42. Because if it disturbs the
Yeah,
school,
absolutely, Lordship will kindly see.
school education.
No, Lord. We want better students, better academic atmosphere. That is what the reason. Very
Because-
few schools are upgraded to others.
Because I am one of those aggrieved persons when our academic year was disturbed.
No, that Andolan, Lord.
Yes, Lordship, we also face-
We all. But in our school, Don Bosco Lordship, we have to, our 1 year was not lost.
No,
Because
from
in 4
next-
months and 6 months, we had 2 annual examinations.
No, next to our batch, I was in 83 batch.
Yes, I was in 84 batch.
So 84 batch got the benefit.
Yes.
So 83 we lost.
Otherwise, my colleague, my contemporaries appeared in matric in 1985. But our
We are
1 year
in
was not lost.
Primary school, sir.
Huh?
We are in primary
Yes,
schools. we
they're
lost
kids.
1 year.
No, because we know that disturbance is created for us.
Lost.
So that is something which always
No.
keeps pinching.
Your Lordship,
One
That
academic
legacy is still continuing. That 1 year, thereafter the whole system, still we are not being able to come out of that system.
No, after 85, everything was okay, but
No, thereafter,
Last
Lordship,
batch.
in post-graduation, Guwahati University, 2 years course took 3 to 4 years. Whereas the same boys who went to Pune or Bombay or Bangalore at that point, they
benefit.
become postgraduate in 2 years' time and they started teaching the same classmates in college
Yes,
because they can join as a professor
yes,
or
yes,
assistant professor.
yes.
Whereas there are other colleagues or classmates are still studying in MA first year.
if your Lordship allows me to submit your.
Oh, yeah,
Lordship,
definitely.
before-
I just, for
before-
one question, I asked the
Before Lord
president.
Advocate General counters me, your Lordship.
Hmm.
My point is, your Lordship, not on that, your Lordship.
Hmm.
It is in their domain, your Lordship, either to establish or to not establish, either to merge. Your Lordship, the way the decision has been taken, your Lordship will kindly come to page 42, your Lordship.
Yes, I'm there.
Yes, your Lordship. Now, your Lordship, this is in respect of your Lordship, Adarsa Vidyalaya, your Lordship, not in respect of Dimau Town High School. It is not that this school is upgraded, your Lordship. A new establishment under PPP mode will come, your Lordship. Now, therefore, your Lordship, this school will have to be merged, your Lordship. The conditions of service of teachers will have to be considered, your Lordship. The future of the students also considered, your Lordship. Now, that is why, in case of continuation of the existing government school, the campus on which will be used for new Adarsa Vidyalaya, it has to be ensured that no new admission takes place in existing school. But the problem is this, your Lordship, that your Lordship, that we are in the midst, already admission has been taken, your Lordship. Classes are going on. In the midst of that, your Lordship, they are now, your Lordship, on 20th, your Lordship, the fresh admission will be taken for so far as in our school itself, this others models for model school, your Lordship. Now, this is ultimately, your Lordship will kindly see, we are not against that. Decision they can always take it. But in the process of taking the decisions, the consideration which they have taken into account, your Lordship, that will be important, your Lordship. Before, your Lordship, they have decided to merge, there will have to be a guideline, your Lordship, which guideline will say that what will be the status, in which school it will be merged. If they decide to merge it in a school, your Lordship, far away from the present school, how can students go? That is one question. That may not be. But therefore, your Lordship, before embarking on this process, they should have, your Lordship, come up with a complete guideline. Shiksha Mitra is there, your Lordship, but Shiksha Mitra, we are not covered by Shiksha Mitra because, your Lordship, our school has more than 100. For being merged with the other school, your Lordship, in the one school, it will have to be less than 100. So, your Lordship, they will have to come up with a fresh guideline. And guideline must say, your Lordship, what will be the status of the teachers, what will be the status of the headmaster in the new school, all without making that exercise, your Lordship. They have suddenly started doing this, and that too, your Lordship, without informing either the governing board, managing committee, or the school headmaster, anyone, your Lordship. That, your Lordship, the manner in which this decision is taken, your Lordship, we are agreed by that, your Lordship. And as a managing committee of the school, your Lordship, we feel that we should come before this honorable court, at least to disclose the facts. This is my case, your Lordship, in nutshell.
Okay.
If Lordship
Yes,
is
Mr.
pleased to
Vijay.
come to page.
So, for two reasons, I find the submission of Mr. Bhattakur appealable. It's appealing, that two submissions. Number one, status of the teachers. That is one. Second is that academic career of the students.
Yes.
There are two main.
Lordship
issues.
may take it from me at this stage, Lordship. None of the service conditions of the teachers will be adversely affected by any means. That Lordship can note down. Because all our guidelines have that. Number two, Lordship will kindly come to page 42. I think this is there is a issue between the school management committee and the local MLA. For that, the student and the overall situation should not suffer. This is purely a government policy decision. May I read it, Lordship? On 2nd May, the chairman, Adarsh Vidyalaya Sangathan and advisor education wrote to the deputy commissioner, Sibsagar. As you are aware that the Demo Town High School in your district is going to be functional as Adarsh Vidyalaya CBSE affiliated English medium school under the administrative control of Adarsh Vidyalaya Sangathan Assam. The tentative date for the ceremonial launch of the school by designated Honorable Minister is fixed on 28th of May 2020. That is means tomorrow. Hence, it is expected that under your able leadership, the following activities are completed within the specified time frame so that the said school can be made operational in a smooth manner. Constitution of School Management Committee, that is number 1. Opening of SMDC bank account to ensure at least 6 rooms are ready and the minor repairing works are done with the support of the Honorable MLA. To provide the status of enrollment of new schools so that the uniform and textbooks can be provided on time. In case of continuation of the existing government school, the campus which will be used for the new Adarsh Vidyalaya, it has been ensured that no new admission takes place in the existing school. If necessary, amalgamation merger proposal for the existing government school may be submitted to the Department of School Education at the earliest. Should have any queries, so and so. So here, there is absolutely nothing adverse against the students as well as the teaching faculty. Now we are at the 11th hour. Tomorrow, the formal launching is going to take place. And it is not a new thing. They have submitted an application before the Chief Minister in December 2022. Lordship, that is at page 29.
No, but here lies the difficulty. You see, this last part you have read. In case of continuation of the existing government school.
The
campus of which will be used for the new
Adarsh Vidyalaya, it has been ensured that no new admission takes place in the existing school. So the existing school is also continuing as of now. 6 room will be used for others. So this is a transition. If tomorrow all the students, because there is a huge craze for the students who are reading in the Seva course to get enrolled in the Adarsh Vidyalaya, which are 18 in numbers in the state now. This is just the beginning for last 1.5 years. This has been done by the government after threadbare discussions at various levels, various decisions were taken in the cabinet also, that we have to give proper and quality education to our students who are reading in the government schools. So we are upgrading our system so that we can be at par with the private schools and the students get best of facilities. No fees is taken from them except some institutional fees, which is very nominal. That was put to challenge, then this Honorable Court, I think, was pleased not to pass any stay order also. I appeared in that case also. If Lordship is pleased to come to page 29. I think there is a ego clash between the existing committee members and the local MLA. That is what we can foresee. But if you read the whole tenor of this writ petition, nothing else. Nobody thinks about the teachers are not before this Honorable Court. Neither are the students.
No, the people face
And we can
difficulties.
assure this, Lordship, if tomorrow, if anything adverse takes place, the teachers would have been the first to come before this Honorable Court.
No, Mr. Saikya, the problem is that many people don't dare to.
No, Lordship,
confront
we
the-
have 80% of the High Court cases belongs to the teachers. If they are so worried and if they are having any fear against the government, they would not have come. We are in a democratic system, Lordship. It is not a banana republic. Lordship will kindly see a public meeting held today on 16 December 2022, Sunday, in the chairmanship of Soneshwar Deuri, President, School Managing and Development Committee, Demo Towns High School, adopted resolution to oppose the proposal of local MLA, demanding to withdraw the proposal for conversion of Demo Town High School to a Adarsh Vidyalaya and decided to place the matter before the higher authority. So this is how the thing started in December. They could have come earlier also, not at this fag when the formal ceremonial launch is tomorrow.
No, but if you take 6 rooms of that school,
Lordship,
if you take 6 rooms out of that school, existing school,
it is not going to affect anything, Lordship. It is not going to take it. The deputy commissioner, because repairing also is done. If we look at the number of students there, the things will come out. Why this school is chosen? Government has not done anything with his eyes closed. In lot of schools in Assam where it is under the elementary education of government department, Lordship, the number of teacher is 20, number of student is 10, that kind of things. Which schools are taken for amalgamation? Where there is acute shortage of teachers or acute shortage of students. Many schools have 4 teachers, no student. Those schools are amalgamated. That is the policy.
What is the status of this school?
That I'll obtain instruction. That instruction has not come to me, because that is why the teachers or the students are not before this honorable court. Everybody is in a happy situation. It's a win-win situation. These are some politically motivated.
No, what are the advantages of this Adarsh Vidyalaya?
Adarsh Vidyalaya, Lordship will kindly come to page 33. It is just like the Kendriya Vidyalaya Sangam, where the education, the quality of teaching are much better than the normal government schools. That is why government with the first phase, Lordship, started with very limited schools. May I read it, Lordship? I have the pleasure and privilege to inform you that
Just a moment,
page 33.
just a moment before you begin. You see,
That's the
now,
scheme.
now the trust, even for the purpose of higher education, medical education, engineering, is all that the education should come in the mother tongue.
Yes.
That is the
Yes,
national
Lordship.
education policy.
Yes, Lord.
And then this,
We are aware of that.
and that this is an English medium again.
Yes. English medium from which level?
Uh,
Not in all subjects. It's a very tricky situation. We have taken opinion of all the experts.
Just explain it to me because I'm not aware
Yes,
of
Lord.
this.
That's the central government scheme for model school year.
Okay.
This is from the advisor to the Honorable Minister's MLAs on 6th of April.
Yes.
May I have the pleasure and privilege to inform you that 18 number of new Adarsh Vidyalaya affiliated English medium schools are going to be functional from the academic session 2023-24 for class 1 to class 6 in the following constituencies. So here, all the schools like in Lakhimpur, Adarsh Vidyalaya, Ghilamari, previously known as Ghilamari Public High School. In Kamrup Rural, Hajo, previous school is Tokadia Sonpara High School. These are all government provincialized schools. Then Sonitpur, previously known as Madhya Jamuguri Government Aided High School, Solabari. Then Soraideo, Mohuamara, Balijan High School, Sipsagar.
It's okay.
So this way we are taking the schools. We are choosing 1 or 2 schools in every district or constituency where there is less number of teachers, less number of students. In either way, they will have to amalgamate under the policy.
Yes.
So that way we have started. Page 34, necessary communications in this regard has already been made to the respective deputy commissioners along with specific guidelines. Respective DCs may be consulted. It may be mentioned that the process of engagement of principal and 5 number of teachers of the respective school is being initiated. The undersigned solicits your advice, cooperation in creating awareness in the locality so as to encourage parents to admit their words in the newly created Adarsh Vidyalaya and also extend necessary supports in making the school a center of excellence in the near future. We are requesting the people to come and take admission because there is acute shortage of students in the government provincial schools. We have to close down many schools, Lordship, because of 0 number of students. This is one way to restart and revamp the education system in our state.
No, but let us accept your submission that it
These
is
are all
okay.
policy in the domain of policy decisions. How can they be aggrieved?
No,
The
no, not that.
teachers what private right has been
No, not that.
infringed.
See, let us assume that what you are submitting is correct. But then there is a transition, the students are otherwise. and
The
Assam-
students are
Assam-
not before this honorable
No,
court.
no,
They are not representing
no.
the students
no,
here.
no. You see, but the court.
The guardians of the students are not before this honorable court.
No, see, you see, that is okay. If somebody is
Then
not
if
here.
that is okay, lordship, first they have to establish before this honorable court by filing a writ petition that their private right has been infringed by the decision of the government.
No, I'm
What
not
private
on that.
right has been infringed?
I'm not on that. You see.
Otherwise, that writ petition is not maintainable at all.
No, if you please hear me. The students are right now in the, under the Assam School of Education mode, that is
Yes, Lord.
SEBA.
Yes.
Now your transition is in the CBSC.
The transition, those students who are already there, they have the options. They can continue with the existing SEBA education. The new students who will take admission in Adarsha Vidyalaya, there may be shifting also. They may opt to join Adarsha Vidyalaya. That option, nobody is pressurizing anybody to come here. As a guardian, suppose I think about this, my daughter's education. Where will I take? If the better education is available, I'll always opt for the better education system. Why Don Bosco Guwahati? It was under education of secondary education department of Assam, SEBA. Now the whole school is converted to CBSC.
You know the answer.
We know the answer. So that because there are certain class of people, they will give all good lectures. They will file petitions here also. If they or lordship is pleased to ask the chairman of this school, I am not just giving generalizing. His daughter or son is not studying here. They will be studying in some private school, either ICSC or CBSC. All these lecture budgets are continuing in the courts and in the media. But when it comes to his own home, he will opt for the Adarsha Vidyalaya, not for the other school where the education level is little bit lower.
No, you can't be so personal, but
No, I'm not. It's a general statement I'm making. I'm not giving any individual thing. That is the normal problem. If lordship hears a television discussion in the evening, all the persons who are giving said that the medium of education should be Assamese or vernacular.
that is
But if
something.
lordship asks them,
No,
the
that is-
question of where your students are studying, they
No,
must
that
be in Mayo school, they must be in some other good
No,
schools.
Mr. Sayyad, that is a very educative, vertical talks.
Educative, when it is concerning the students
No.
belonging to the farmers, belonging to the
It
Khelawalas and Rickshawalas.
it teaches you how to shout, which fortunately in this code also, at times we are now finding, which was not
No,
there. earlier.
that is the effect of Arnab Goswami's debate, lordship. That is there already.
I don't know, I am not personal, but yes, there is a very educative channel when it comes to know how to learn shouting.
When at that point, at one point of time, there was this MBA admission, then group discussion. If somebody is to get admission, you have to get the marks as along with that, you have to perform well in the group discussion. So whoever talks more, he gets an preference of the other students.
Yes, of the others, yes.
So now here the case is very different. Lord. It is a purely a government policy decision. First, they have to establish before this honorable court what is their grievance. They also are admitting that we are not against this. Several times I have heard the other side. But the procedure, they are a little bit annoyed. What is the procedure? Let them first place the procedure in a format that these are the procedures to be followed. Where is that violation?
No,
There is a procedure, definitely.
No,
We
Mr.
have
Sehgal,
followed.
Mr.
It is a
Sehgal.
long drawn process. All of a sudden, overnight, this Adarsha Vidyalaya concept has not come.
Mr. Sehgal, please try to see the practical aspect.
The
You see-
practical aspect, lordship, if they have
No,
established.
let me tell you an example. You see, student of the ward of A, the son or the daughter of A is attending a school with, say, with a disadvantage of just as you are proposing that the present education system is a disadvantageous system. So, child of A is in that same school with a disadvantageous position. A child of B is in the Adarsh Vidyalaya, he is having a better uniform as having an English education.
Yes,
So there'll be the diaspora, you see, there'll be a.
yes.
there'll be a
Now, lordship will, yes, that answer, the last line of page 34.
34.
last paragraph of page 34. When this chairman of the Adarsa Vidyalaya wrote to all the honorable ministers and MLAs,
Yes.
the undersigned solicits your active cooperation in creating awareness in the locality so that to encourage parents to admit their wards in the newly created Adarsa Vidyalaya and also extend necessary support in making the school a center of excellence in near future. So we are encouraging, we are requesting people to come here. The guardian will take a call, which is better for their wards. So we are opening the gates and everything is under the control of government. Vote belongs to the state. It is not that everybody will have to study in CBSE format. Those who want to study in SEBA, we are running the SEBA also. We are trying to revamp the SEBA education also. But if somebody aspires to become a doctor or an engineer, if he starts reading science in English medium from class 6 onwards, he is always in a better position.
You are right there. You are right there.
These are the factors which are the opinion is taken from the experts. It is not the decision of the officials.
No, but few things you'll have to take
We will
instructions.
definitely take instruction,
The-
but
the-
Lordship may not be pleased to pass any stay order at this stage.
No, what I'm on is, you see, the last.
Tomorrow, Monday, I will produce all the
The-
records and what is the overall objective of Adarsa
The
Vidyalaya.
last point which I made, that you see, if supposing there are some students who don't want to opt from CBSE to, SEBA to CBSE, correct? For them also, the government should ensure, especially if the two schools are running from the same campus, that there will not be a discrimination so far as the uniforms. and
I'll
those things are
take note of that, Lordship. This is
Because if,
just starting. This is a transition
no,
period.
but you understand what I'm
Yes.
trying to point out.
Yes, Lordship. There
Because-
should not be discrimination within the same campus.
This,
Exactly, Lordship.
because if you give sports to school of Adarsa Vidyalaya and don't give those facilities to the
Yeah,
school of
To
CBSE.
choose this school, lot of exercise has been done. It is not that, Lordship, abruptly this particular school, the local people's opinion, the public representatives' opinion. Everybody's opinion, I'll place it, Lordship. Whatever that query I could understand, that there should not be any discrimination among the students of these two different category of schools or the curriculums
In the same campus.
in the same campus.
May I
Yes.
please, Your Lordship, I just want.
On
to-
Monday, Lordship will take up the matter.
I-
I'll bring complete instruction.
I will submit your Lordship. First of all, Your Lordship, certain statements are made by the learned Advocate General, Your Lordship, and with due respect, Your Lordship, and with all humility in my command, Your Lordship, that has nothing to do with the case I have presented, Your Lordship. I have not made any allegations against the MLA concerned or anybody else. What I am saying that since MLA only on the basis of a recommendation of an MLA, this exercise should not have been carried out, number one. Number two, Your Lordship, what we are submitting, Your Lordship, that the way this decision has been taken, that is the problem. And Your Lordship will kindly see one aspect of the matter, Your Lordship. Your Lordship will get that in that scheme, Your Lordship, for the Adarsa Vidyalaya, which will be, Your Lordship, which will be a PPP mode schools, Your Lordship. The student teacher ratio will be 1:40. When they have, the authority has even assuming that authority has decided to amalgamate this with the other schools. Have they considered that particular aspect, Your Lordship, that what will be the teacher-student ratio? And if it is, if they had, Your Lordship, where are the documents, Your Lordship? Where are the decisions, guidelines, Your Lordship? They have not made, ultimately, Your Lordship, decisions taken by the government in the interest of the public, that will have to be a certain public, it will have to be in the public domain, Your Lordship.
No, you see, for that purpose, we may not be with you. The reason is that if there is a transition, and then they say that the board of this Adarsh Vidyalaya will be followed. Adarsh Vidyalaya must have a scheme.
That scheme, Your Lordship, I have already
It's
handed
okay,
over.
I have not read that, but
Lordship.
there must be a scheme. So if that scheme is there, the transition would be complete. It will be on that scheme only. If the student ratio is 1:14, it will be 1:14. If it is 1:40, they will follow 1:40, whatever is there.
1:40 for Adarsa Vidyalaya, Your
No,
Lordship.
no, that's what I'm saying. I'm saying if it is 14, they will follow 14. If there's a ratio of 40, they'll follow that ratio, because you see,
That is where my case is, Your Lordship. That guidelines should have been in place before they embark on this particular exercise. My case is very simple to that extent, Your Lordship. I am not saying that the authority has no power.
Let me test your argument. You see, in few states of the Northeast, earlier there were certain litigations which were permitted only in the customary courts.
Lordship.
Correct. Now, the government as well as this court enforced the civil procedure in few of the states. You see, a citizen can't be consulted so far as the transition is concerned, because if it is a civil court rules and orders and CP is already in place. So therefore, it's not necessary for us to advertise that once it is not in the customary court but is in a civil court, then this will be the policy in which the education will be run. Correct. So if there is already a policy of Adarsh Vidyalaya in which is there in the state, for the purpose of transition, they don't have to advertise that.
No, Your Lordship, I am not on that, Your Lordship. Yes, Your Lordship, no requirement of publishing it, Your Lordship. But the stakeholders, Your Lordship, the IS, Your Lordship, the school authorities, they should have been, Your Lordship, informed about these guidelines and this procedure. I am not about Adarsh Vidyalaya. Adarsh Vidyalaya guideline is there, that is before Your Lordship. But what is the guideline for the other schools, Your Lordship, where they have going to establish the other schools and merge the schools with other.
No, that will take the
yes, Your Lordship,
statement of the Advocate General, because once he makes that statement,
I have
then-
some information, additional information.
because then what happens is that if he assures the court that the service conditions of the teachers
that is Your Lordship.
and
What
the
is-
students will not be affected, we'll take that. into
Absolutely
account.
no, absolutely no. The school, the district level committee, which looks after the amalgamation part, has already recommended that Demo Town High School amalgamation with Demo Higher Secondary School at a distance between Demo Town High School and Higher Secondary School is 2 kilometers. And Demo Town High School has low enrollment. We may propose the amalgamation of Demo Town High School with Demo Higher Secondary School as per the Shiksha Kshetra scheme. And the chart says the number of students.
I did not get that. Please explain it to me.
This is Demo Town High School,
Hmm.
the school management. The district level committee under the amalgamation scheme, Lordship, they have to look into the number of teachers and the students, that PTR ratio. They have already done a meeting and recommended that Demo Town High School should be amalgamated with Demo Higher Secondary School, which is within a distance of 2 kilometers. All the students and teachers will go there. That is a recommendation, and these parameters are time tested before this honorable court. The teachers already, this school will amalgamate with higher secondary school. And there in the scheme, the teachers' service conditions are well protected. So that challenge was also upheld, that challenge was negated by this honorable court on earlier occasion. Now, the number of students class-wise of this school, Demo High School, class 6, it is 14.
Just a moment.
Class 7, it is 15.
Just a moment.
Total 14, 16.
Class 6, it is,
Class 6, it is 14, 1-4.
yes.
Class 5, it is 15. Class 8, it is 16. Class 9, it is
Okay,
33.
just a moment. Class 8 is,
Class 8 is 16, 1-6.
yes.
Class 9 is 33. And class 10 is 27. Whereas the other nearest school, that is Demo Higher Secondary School,
Just a moment. This name of the school of Mr. Bhattagu is
Demo-
Demo Town HS School.
Demo Town High School. Another one is Demo Town HS School.
Demo Town
Town.
HS School. Okay,
Yes.
here,
Demo Town High School, it is, I have already spoken. The other school with whom it is proposed to be amalgamated is Demo Town Higher Secondary School.
yes.
Here, class 6, 106, class 7, 93, class 8, 92, class 10, class 9, sorry, class 8, 92, class 9, 119, class 10, 98, class 11 0, because the admission is yet to take place, and class 12 58. And the remarks of the committee is, concerned proposed high school may be amalgamated with nearest school, that is demo higher secondary school. To accommodate all students of the proposed, furniture should be shifted to demo HSS school. So rooms are also available there. That is why my humble submission, that teachers, their guardians, and that none of them have approached this honorable court. And only thing they are agreed is that the procedure is not correct.
To that extent, we can be agreed with your worship.
Yes, they can be agreed. But that procedural lapses, according to them, first there should be a procedure. The procedure we are saying now, that these are the calculations, these are the facts we have collected, and on the basis of those facts, that recommendation has taken place.
Okay. Heard. Mr. S. Bhattacharya and counsel for the petitioners, and Mr. D. Saikala, the Advocate General, assisted by Mr. CKS, SMT Chisti, standing counsel for the School Education Department, appearing for respondent numbers 1, 2, and 3.
Oh, my friend.
For Mr. P. Saikya, and the government advocate appears for respondent number 4. Who's for 5 and 6?
5 and 6, Lordship, we can appear, Lordship, on. But 6, no. 6 is by name. That
Okay.
is why it is said that the ego clash is there. Why he is named as a party, Noni Gopal Mohanto? That shows there is some personal grievance.
That may be a joint of necessary
This
parties.
has been issued.
How can the name be given, Lordship?
That is, there is a reason, your worship.
No, if it is malice, then he has to give a name.
Yes, your worship.
No, Lordship,
No, no,
in
we
my
have
humble
not
submission,
malice, your
he
worship.
is holding the post of chairman, others of Vidyalaya Sangathan. If we file a case against KVS, do you name that person who is holding that post? Tomorrow he may be not there.
Because your lordship.
That is why I'm saying that there is some private interest involved in this case.
It's okay.
Your lordship will kindly see that page 33, your lordship. It has been issued as a your lordship chairman of the Adarsa Vidyalaya. Not,
No, but Mr. Advocate General is right, by name.
lordship, I should not have. You should not have.
Unless there's a malice involved. If you have pleaded malice.
Lordship,
then
I
it's okay.
understand. your lordship.
I don't think there's any malice in the
In fact,
pleadings.
your
No, I
lordship,
don't
we have
know.
not released
No,
any
there's no
malice.
malafide.
That
No, no,
much,
we have not released them.
That is why name is not required.
you're right.
It should have been as a chairperson, your lordship, Adarsa Vidyalaya Sangathan.
For Advocate General, you're right, 1, 2, 3, and 5. You want to strike out the name of the
Lordship.
person?
Lordship.
Next para. The learned counsel for the petitioner. Praise D for allowing him to strike out the name of Professor within bracket doctor, bracket closed, Nani NANI Gopal Mohanto. From the area of from the description of respondent number 6. The period is allowed and the name of the person which stand deleted, and the cost title for respondent number 6 would now be Adarsh Vidyalaya Sangathan, Assam, represented by chairman cum advisor, education to the government of Assam. Rest of the cost title is empty. We give the name full cost title at page 5 and 6. First, the registry shall carry out the necessary correction in the cost title. No, you will have to do it. Mr. The learned counsel for the petitioner shall do the necessary correction in the cost title in the presence of registered judicial, so that the central registry can also be corrected. Next one. The authorities in the school education department have taken a decision to establish what is the name? Adarsh Vidyalaya. Adarsh Vidyalaya in the premises of the Dimau Town High School. First of- The grievance of the petitioners is that the Adarsh Vidyalaya is thought to be first on the Dimau Town High School at the behest of the local MLA without any consultative process with the stakeholders of the Dimau Town High School, i.e. the school managing committee, the headmaster. It's a headmaster in the school? Headmaster or head teacher? Head teacher. Headmaster or head teacher?
Headmaster.
And they were consulted at paragraph 8.
It's okay, his submission.
His petition, paragraph 8, they have said they
No,
were
but
consulted.
His submission was that he is not consulted.
Yes, Lordship will kindly see.
No, Your Lordship, we have not said you have consulted.
They have opposed, but they were consulted. They were
No,
part
Your
of
Lordship, there is no admission that we have been consulted.
I don't know.
paragraph 8, page 8.
And demanded to withdraw the proposal forwarded by member of Legislative Assembly, Thorough Legislative Assembly, and decided to communicate their demands to the higher authority. That's all, Your Lordship.
The said meeting presided over the president of the school management. That means he presided over the meeting.
No, I am not president, Your Lordship.
President, that
I am the,
so
I am the secretary.
they have internal bickers within the committee then.
No, the petitioner after coming to learn of the proposal was the call for a public meeting regarding conversions and other and so and so. The committee. Had already said, they opposed the proposal.
They
Oppose the
oppose.
proposal.
And they presided, the president of this management committee.
That
school
is, we are
management committee.
opposed, the president presided and opposed, Your Lordship. Where is the question of consultation here,
Yeah.
Your Lordship?
They are not their private property.
No, it's okay, but
My
that is his
submission is
submission and
that-
recording his submission.
Yes.
Were not consulted. And therefore, in a public meeting called on 18/12/2022, a decision was taken to oppose the establishment of Adarsh Vidyalaya in place of Dimau Town High School. That's right. The learned counsel for the petitioners has submitted that the decision was taken in a haste and that prior to the proposal, the modalities of the existing teaching and non-teaching staff and the future of the students were not included in any policy decision of the state. So accordingly, the decision of the state authorities in starting a Adarsh Vidyalaya under the PPP mode is challenged by filing this petition under Article 226 of the Constitution of India, whereby the petitioners have prayed for questioning of the communication dated 6/4/2023 and 2/5/2023. And the petitions have also prayed for an interim relief to stay the operation of the said communications. Next paragraph. Opposing the prayer for interim relief, the learned Advocate General has submitted that the state has taken a policy decision to start Adarsh Vidyalaya in a PPP mode under the Adarsh Vidyalaya Sangathan, Assam. First off, it is submitted that on issuance of notice, the state would file a detailed affidavit to disclose the process and the process of such a decision. First off, nonetheless, it is submitted that as per instructions provided to him, the Adarsh Vidyalaya would have a CBSE curriculum and would provide. Where is that English you said? Where is that? The English 6 to 8, you were showing some document.
Last page.
Last page.
There are two documents, page 33 and page 42.
Page 33.
33. There is no indication of any PPP. That is, I don't know how from where they have got that concept. But there is no intention of the government to make them PPP mode.
Okay, it's okay. You're saying it is not PPP.
Not from these two documents, page 33, there is no indication, no whisper.
For Advocate General, don't write a PPP mode. Huh? Any submissions don't write PPP mode. So it is submitted that the CBSE affiliated English medium Adarsh Vidyalaya would be functional from for the selection 2023-24 for class 1 to class 6. And in the policy decision taken on 6/4/2023, in respect of Sibsagar, falling under Thaura, THOWRA constituency, Adarsh Vidyalaya was mooted at Demo Town High School. Next, but it is also submitted that as per his instructions provided to him, a policy decision has also been taken. The merger of Demo Town High School.
Policy, the final recommendation from the district.
Recommendation has been made
District level committee.
by the district level committee for amalgamation of Demo Town High School with a nearby located Demo Town Higher Secondary School,
Higher secondary school.
which is located at a distance of about 2 kilometers. First, it is submitted that the said recommendation was made by taking into account the enrollment in the Demo Town High School, which is 15 for class 5, 14 for class 6. 7, you did not give the figure.
I have the figure.
Okay, just give a gap.
1/5.
1/5 for the
Yes.
7,
Plus 7, 15.
8, 16 for 8, 33 for 9, and 27 for 10.
Yes, Lord.
Post. On a query made by the court, the Make it next paragraph. On the query of the court, the learned Advocate General has submitted that insofar as his instructions are concerned, with the opening of Adarsha Vidyalaya at Demo Town High School, the education of the existing students and the conditions of service of the existing teachers would not be adversely affected. So it is submitted that student would have an option to get to be admitted in the Adarsh Vidyalaya if they elect to do so, or otherwise the students will continue to be imparted education in the existing manner in the Demo Town High School
Till it is amalgamated with the
till it is amalgamated with the till
amalgamation process.
amalgamation process is
Is
concluded.
taken to the logical conclusion.
So it's taken to a logical conclusion. Which according to him is still at the recommendation stage.
No.
It is also submitted that the inaugural ceremony for the formal inaugural of the said Adarsh Vidyalaya is stated on
Tomorrow.
2023.
And my another submission, there is a acute delay and latches on the part of the reputation to approach this court, because in December their request was turned down. So from December till this today, 6-7 months elapses there.
Okay. So it is also submitted that in view of the delay in approaching the court, petitioners may not be entitled to any interim relief. Next paragraph. Issue notice of motion returnable on when within 2 weeks he'll be able to
Yes, Lord.
is 19th. If you see it on 2nd of June, Mr. Shisti,
Yes, your second object, perfect.
2/6/2023. Requisite extra copies of the petition be served on the learned State and Department Council. Next paragraph. Pending recasting of the cost title for respondent number 6. SMT Chisti Learned study person for the School Education Department accepts notice for the respondent number 6. Next paragraph. Consider the prayer for interim relief. Next paragraph. As the Advocate General has assured the court that the education of the students who are already admitted in Demo Higher Secondary School,
High school.
town high school, will not, and the service conditions of the teaching staff and non-teaching staff would not be adversely affected. The decision to start a Adarsh Vidyalaya in the said in the campus of the Demo Town High School being a policy decision. The court is not inclined to stay the operation of the impugn communications. Next paragraph. Nonetheless, it is also provided that the decision of the government for establishment of the Adarsh Vidyalaya at Demo Town High School would be subject to further adjudication that may be made in this matter.
Highly obliged.
Deeply obliged.
This policy decision, you take it, you give us a copy on the next date. Mr. Sekia, if you have instructions, I would also like to provide that if it is till the time it is not it's not shifted. If the students are in the same school, what you call similar benefits be given to the students, because if you give uniform, better uniform,
Absolutely no discrimination on that, Lordship.
but you inform them,
Yes, yes.
yes, I'm not pinning
Otherwise,
down, but please
even
see
those
that-
who are not others of Vidyalaya, they are getting free textbook, free uniform.
No, that is okay, but you see, you give a different quality uniform in one school. Please see that,
Yes,
please
Lord.
ensure that
Will
there should not be, because
I'll directly give the
you
instruction.
see, because I'll tell you why. There's a reason why I'm very concerned with this. My son was in the kindergarten at one point of time. And in the school, on birthdays, they celebrate birthdays and costly gifts are given to students. One parent, whom I knew, he was otherwise affluent, no problem with his finances. He came to the school and protested when one student gave costly gifts, return gifts to the other students. And he had a reason. He said that today I can give some costly gifts, but if tomorrow, if another student in this school, he can't afford, then in his home, there will be a disturbance because the child would now feel deprived. And therefore, for other children, he came and protested that maybe in this class, there will be students who are of low financial capacity parents, and they would be aggrieved if their son can't, their children can't compete, and the school withdraw their gift system. And the protest came from a person who was of an affluent class. And he was thoughtful for a student
Who cannot afford.
who cannot afford. And therefore, that
The
is,
situation is absolutely not like that
Uh-huh.
here.
well, that is, you see,
In
Uh,
fact, here,
25
here the
years.
intention of the government is that to give quality education to the downtrodden who cannot afford and enroll
that is-
themselves in private schools.
No, that is okay.
That is the objective here.
No, I'm not on the objective. That's why I'm not giving an interim. But you see, what I'm concerned is that there should not be a discrimination in the same campus. Please ensure that.
Absolutely, will ensure that.
Ensure that. Because if
We
you're giving,
appreciate this concern, but we'll
if
immediately.
you're giving good uniforms to student of X school,
No, no, no.
or Mr. Whatever school also, please provide that same.
We'll rather request all the students should get enrolled here.
No, that is okay.
They're 15, 16,
That
17.
is okay, but please don't discriminate in a child.
No, we'll not do that. That is not in the intention of the government.
In a
The
child.
intention of the government is to give equal education to our downtrodden students.
No, I'm not doubting that, but.
Because the
discrimination-
parents are deeply burdened. If a small time earner have to enroll his student in a private school, the money he will have to shell out.
You're right. No discrimination. They can come back.
We are local colonies.
Taken, my lord. Now, my lord, as per the, my lord, advertisement, my lord, for the general category candidate, my lord, 60% marks are to be obtained in TET. And my lord, so far as, my lord, the reserve category candidates are concerned, my lord, they can, my lord, qualify and they're eligible, my lord, if they're 55% of marks, my lord. Now, here what happened, my lord, in this particular case, my lord, there were five, my lord, there were 4 or 5 posts still vacant, my lord, general category. There were no candidates. And my lord, therefore, she's claiming, my lord, she ought to have been considered against general category post, my lord. Because, my lord, otherwise, though she's the reserve category candidate, my lord, since there being no candidate, my lord, for the general category, who are ahead of her. In fact, there are no candidates at all. So, like, in that circumstances, my lord, her case ought to have been considered, my lord, for the purpose of as a general category candidate, my lord, and she ought to have been selected for the purpose. That is basically my case. My lord. Now, my lord, and my lord, lordship will see, my lord, the selection process. It is basically, my lord, based on the marks obtained in the various examinations. That will lordship will find at page 23 in terms of the advertisement.
But, Mr. Bhatta,
Criteria for selection of
not
postgraduate
that.
teachers.
No, not that. You see, is it a case that she is otherwise secured more than the what you call general category candidates? No.
Yes, because my lord, there are no other candidates. So therefore, my lord, she is the candidate who is having, my lord, the marks. My lord. So this, had there been other candidates, things would have been different. My lord.
Okay.
But to my knowledge, there are no other candidates, my lord, and therefore she ought to have been, my lord, included. My lord. In fact, my lord, lordship will see the page 23, my lord, the advertisement, my lord, the criteria for selection. Now, my lord,
No, it's okay. We will take it that you have that criteria, Mr. Saikya. If there is no other candidate in the general category, then
Yes.
why petition? has not
So
been selected?
for general category, in the TET examination, the candidate must get 60%
Okay.
to qualify to apply for general category. She did not get it. She
Please come again. I couldn't
no,
get
no.
it.
For the SC and ST, you have to get 55%.
Okay.
For general category, you have to get
60.
one has 60%. So those who got 60%, they will be considered for the general category seats. Her case is that she does not qualify TET as per the general category norms.
Okay.
So that is the written instructions I have received.
Then you can't be treated like that.
Well, there are judgments.
I will file affidavit to that.
Well, there are 2 judgments, my lord, which say that there is no bar as such. If there is no candidate, and or if she overscores, my lord, because this doesn't take up the level playing field. It's only qualifying for the qualifying purpose, my lord. Since
Show me that.
yes, my lord. One is, my lord, given as my lord, citations are given already, my lord, I can.
And there is another disqualification, Lordship, regarding the age. The general category, it is 38. The
Then it is 41.
otherwise it is 45 year, 43, 41 for MOBC and 43 for SC/ST. So see, her age is 42. So she will not qualify to get into the general category on the basis of age also. On 2 counts, he is disqualified.
My lord, that is also covered by the judgments, my lord, I'm, my lord, carrying, my lord.
Yes.
One is, my lord, the Vikas, my lord, first, my lord, is the Jitendra Kumar's decision, my lord. That is reported in, my lord, 2010, 3 SCC, my lord, 119, my lord.
That's 9.
2010, 3 SCC.
My lord, 119, 2010, 3 SCC, 119. Jitendra Kumar Singh versus State of Uttar Pradesh.
Yes.
My lord, paragraph 48, lordship may take up, man.
Yes. How does it start?
In view of the opposite facts, my lord. Has your lordship got it, my lord?
No. Yes. Yes.
In view of the opposite facts, we have the considered opinion that the submission of the appellant the reduction in fees or age would deprive the candidate belong to the reserved category of an opportunity to compete against general category candidates without any foundation. It is to be noticed that the reserved category candidates have not been given any advantage in the selection process. All the candidates have to appear in the same written test and face the same interview. Here, my lord, the marks are the criteria, my lord. It is therefore quite apparent that the concession in fees and age relaxations only enable certain candidates belonging to the reserved category to fall in the zone of consideration. The concession in age does not in any manner tilt the balance in favor of the reserved category candidates in preparation of the final or merit list. So here, my lord, basically the age relaxation was given, my lord. And my lord, there, my lord, this was not taken, my lord, saying that it doesn't, my lord, disturb the level playing field, my lord. That is, my lord, what, my lord, the learned court, my lord, has finally held, my lord. Now, my lord, then, my lord, the lordship, my lord, this judgment talks about the reservations, my lord, criteria and all, my lord. Then, my lord, So paragraph 74, my lord, on this.
Yes.
It is not disputed before us that the election is only given to the members of scheduled caste, scheduled tribes and OBCs, but also the dependents of freedom fighters. Such age relaxation is also given to ex-servicemen to the extent of the service rendered in the army plus 3 years. In fact, the education qualifications in this case of ex-army men is only intermediate equivalent, whereas for general category candidate, it is graduation. It is accepted before us that the ex-servicemen complete not only in their own category, but also with the general category candidates. No grievance has been made against any of the appellant petitioners with regard to age relaxation granted to the ex-servicemen. Similarly, the dependents of freedom fighters are also free to compete in general category if they score more marks than the last candidate in the general category. Therefore, we do not find much substance in submission of learned counsel for the appellant that relaxation age weighs the pitch in favor of the reserved category at the expense of the general category. In our opinion, the relaxation in the age does not in any manner upset the level playing field. It is not possible to accept the submission of the learned counsel of the appellants that election age or the concession in fees would in any manner be an infringement of Article 16(1) of the Constitution of India. The concessions are provisions pertaining to the eligibility of the candidate to appear in the competitive examination. At the time when the concessions are availed, the open competition has not commenced. It commences when all the candidates fulfill the eligibility criteria, namely qualifications, age, preliminary written test, and physical tests are permitted to sit in the written examination. With age relaxation and the fees concession, the reserved category candidates are merely brought within the zone of consideration so that they can participate in the open competition on merit. Once the candidate participates in the written examination, it is immaterial as to which category the candidate belongs. All the candidates to be declared eligible has participated in the preliminary test, so also in the physical test. It is only thereafter the successful candidates have been permitted to participate in the open competition. Mr. Rao so-and-so has suggested to ensure that there is a level playing field in operation, an open competition. However, Section 8 lowers the level of playing field by providing concessions in respect of fees or any competitive examination or interview and relaxation of upper limit. We are unable to accept the aforesaid submissions. Section 636 is clear and ambiguous. It clearly provides the reserve category candidates who get selected on the basis of merit in open competition, with general category candidates shall not be adjusted against reserve vacancies. Section 316 and Section 8 are interconnected. Expression open competition, Section 36 clearly provides that all eligible candidates have to be assessed on the same criteria. We have already noticed earlier that all the candidates, irrespective of the category they belong to, have been subject to uniform selection criteria. All of them have participated in the preliminary written test and the physical test that followed by the main written test and interview. Such being the position, we are unable to accept the submission of the learned counsel for the appellant petitioner that reserved category candidates having availed age relaxation of age are disqualified to be adjusted against open category seats. It was perhaps to avoid any further confusion that the state of Uttar Pradesh issued directions to ensure compliance with the various provisions of the Act. Non-compliance with an officer was in fact not more punishable with imprisonment with extent so and so and so. But in this case, then in another case, thereafter, following this, Vikas Sankla, 2017-1 SCC 350.
No, but in this case, you are referring to this, what do you call this, Jitendra Kumar case.
Merit.
Here, is it the case that the qualifying marks?
No, there was a
It's
case of
also-
age relaxation, now Vikas Sankla 2017. That is that also deals with the issue of having lesser qualifying marks for the reserve category candidates in TET examination. Vikas Sankla versus Vikas Kumar Agarwal, it is 2017-1 SCC 350.
2017,
17, my lord, one
SCC?
SCC. 350. Vikas Sankla versus my lord, Vikas Kumar Agarwal, my lord.
no, here you give the citation 2017, 12 SCC 680.
My lord.
You give a citation 2017, 12 SCC 680.
Oh, my lord, sorry, there's some mistake, my lord. No, my lord, there, 12, but 12 is also there, my lord. Look, 12 of course is already, but 12, 17,
Now you're relying on which citation?
17, 1, my lord. So 12 also I given, my lord, that's another one, my lord.
2017.
Yes, my lord. One SCC, 350, my lord.
350.
350.
50. Yes. Mr. Datta, before this, please clarify one thing.
My lord.
In this, in your case,
My lord.
in your examination, whatever was held, for reserve category and the unreserved category, the marks are same or there's a difference in marks?
Only for the purpose of qualifying in TET, my lord. The TET, for TET purpose, my lord, 55% is eligible for reserve category candidates.
For reserve category.
Formula
You got
jet,
how much?
I got 55%, my lord.
You got
If, my lord,
55%.
yes, well, both the subjects are taken into
But
consideration.
this case you are citing, I've not gone through it fully, but if I recollect it correctly, in this case, the one of the finding of the Supreme Court was that no concession is given to reserve category candidate for availing for relaxation in pass marks.
My lord.
I think one of the observations.
Exactly,
in
my
this case
lord.
is that
Here, what I'm saying, my lord, ultimately, our marks are being, my lord, calculated on the basis of the marks we have received in various examinations from higher secondary, my lord, HSS onwards. So all these are aggregated, taken into account. Now, my lord, for example, if I get 55% marks in the TET, my lord, I will get 55 out of 100. A person who gets 60, he will get 60 out of 100. When all these aggregate marks are taken into account, if my aggregate marks are more than a general category candidate, then, my lord, there is no denial of level playing field to the other person. So all the subjects, all the examinations taken together, if I get, say, let's say 400 and other gets 405, he scores over me. But if he gets lesser, then I score over him. And therefore, there's no denial of the level playing field. It's only for the purpose of qualifying the reserve category candidate to participate in the process that relaxation is given. But when it comes to the ultimate selection process, that per se does not change anything so far the merit is concerned, because he or she has to come on the merit of the overall merit. So that is where this relaxation does not give any advantage to the person who has come in from the reserve category under relaxed conditions. Had it been a case where the relaxed category candidate would have got extra benefit for that, then perhaps things would have been different. It's just for the purpose of qualifying that they can, so that they can participate in the process. They're given that
category, the regulation says that it is 60.
60 for general category. But since there are no candidates at all, that's what I'm saying, Malak. Had there been a candidate who had got 60 and had that candidate got equal marks as me, that person would have got over. I wouldn't have any case, because all the marks of all the paper subjects which had appeared from right from higher secondary HSLC, those would have been counted. So that ultimate
deal with this issue here. How does this deal with that?
Here also, my lord, this is dealt with the relaxation part, my lord, given to my lord TET qualified candidates, my lord. My lord, from
Because if I.
para 38 onwards, my lord, just
Because if I remember it correctly,
my lord.
this is a case where a challenge was made that persons who are scoring less than 60
Right.
should not be given that TET.
Given
That- given that TET.
No, my lord,
60% was the qualifying mark,
My lord,
and
my
therefore any person below that would not get it.
my lord.
So it is in that context that the adjudication is being taken.
No, my lord. This was also with regard to recruitment process, my lord. Okay. This is also recruitment process, my lord. Lordship will see my lord, issues to be decided. Paragraph 38 onwards, my lord. Whether a reserve category candidate who secured better than general category candidate in recruitment examination can be denied migration to general seats on the basis that avail relaxation in TET. This is one of the issues that was framed up, 38.3, my lord. 38.3, my lord. The question number 38.3 in paragraph number 38, question number 3, my lord. Whether reserve category candidates who secured better than general category candidates in recruitment examination can be denied migration to general seats on the basis that they had availed relaxation in TET.
Yes. First line starts like that. The policy decision was contained in letter dated so issued by state government, thereby allowing migration of reserve category candidates to general category who had scored better than general category candidates.
Well,
This was the how it was decided.
well, here, of course, in this here, my lord, in our case, my lord, there is nothing to adverse to show, my lord, that general category candidate, my lord, she cannot compete in the general category post, my lord, even if it gets higher marks, my lord. Had there been some condition, my lord, that the general category candidates, my lord, reserve category candidates, my lord, having, my lord, entered into the fray with, my lord, relaxed standards, cannot be, my lord, compared against general, my lord, category candidate, my lord, cannot be, my lord, converted into a general category post, my lord, having, my lord, got them, even having got the marks, my lord, then perhaps things should have been different. There's nothing in the advertisement to indicate, my lord, that the reserve category candidates are not going to be considered for general category candidate
Because
post.
the general principle is that if the seats remain vacant, they
My
will
lord.
be advertised for the next recruitment process. It can't be that all the seats will be eaten up. Because you see, you can't have a cake and eat it too. You take relaxation when you get into competition.
My lord.
You get age relaxation, you get other relaxations also,
My lord.
55%, and then you compete. Then you don't score more than 60%,
My
which
lord.
is reserved for unreserved category candidate. So, but then you want that you should be adjusted against the unreserved category candidates, and thereby the vacancy which would be otherwise which would be rolled over, or it will be given to the next recruitment process will be eaten up.
My lord.
You come into the reserve category without having two qualifications. Number one, age and the marks.
My lord,
But you come into the what you call the unreserved category.
my lord, my case is, my lord, here for my lord, in this particular selection process, my lord, there is a, my lord, otherwise, my lord, there is no bar as such, my lord, for relaxed category candidates to come into the, my lord, general category candidate.
But you must score more. That is what I have started.
That's the reason, my lord,
That's the
if
first
if
question
the
I asked
entire, my lord, entire selection process, that's what, if the entire selection process is taken into consideration, that's what I'm saying, my lord. So for the selection is concerned, my lord, if I score over a general category candidate, my lord, therefore, my
You
lord,
see, you have a disadvantage.
my lord,
You see, now let me put you the question. Number one, can the government
my lord,
offer you this what do you call this appointment? Because you see, like you, there will be hundreds of other persons
my lord.
who are in the fringe. What do you call 55% or more, but they did not get an opportunity to come to court. So we can't have that done exclusively for you, because if your case is considered, it must be considered with all other candidates who are just like you.
Here, what has happened, my lord? In fact, there are almost 5 posts vacant, my lord. No
Well,
one,
there may be
there
five,
are no,
there
there are
may
no
be
candidates
50,
at all. my
but
lord.
it will be rolled over. It
There are no candidates at all, my lord,
will
because
be available for the next recruitment process if there is a leftover. But we can't permit an unqualified person to be appointed. You-
my lord,
you-
my lord, my case, my lord, is that since, my lord, this is only a qualifying, my lord, criteria, my lord. They have qualified, my lord, and on the basis of, my lord,
qualified on the basis of relaxation.
relaxation,
criteria.
my lord. But then ultimately, my lord, it has to be, my lord, it has the ultimate analysis, my lord, there has to be, my lord, the
No,
system.
I can issue a notice, but I'm not giving an interim.
Well, I'm,
Because that-
I'm taking a notice at this statement.
Because it's not a case of.
Well, I'm taking a notice at this statement, nothing more than that.
Yes, Lordship, notice. There's a direct contra case I will place during the hearing.
Let's examine them. I'm taking a notice at this statement, nothing more than that.
Whatever is said, fallen from Lordship, that has precisely the Supreme Court's also said the same.
At this time, the file, let me consult with the petitioner. Mr. D. Cycle and the Advocate General. Assisted by Mr. SMT Chisti and the counsel for all the respondents are present. Study counsel for all the respondents are present. Next, issue notice of motion returnable on. In 4 weeks, we'll make it 4 weeks. So requisite extra copies of the petition be served on the 11th. Standing counsel for the school education department in course of the day. Who accepts notice on behalf of all the respondents. List after 4 weeks.
Highly obliged.
Item number 8.
My lord, the petitioners are
Yes.
debt qualified candidate. They have applied pursuant to the advertisement issued by the Director of Elementary Education.
Just a moment. Watch.
Similar cases are.
That's all. Unless I look at the notes, I won't remember what I'm referring to. Just give me 1 minute. Yes, you are asking for the sports marks, correct? What is the eligibility criteria for getting that sports marks? What is the requirement of the policy?
Yes, page 24 advertisement and page 27 is the eligibility criteria. Right here.
Yes, 25, yes.
This is that page 24 is the advertisement and page 27 is the last portion of the advertisement regarding marking pattern. Serial number 5 and 6. Must represent the state on certificate in recognized sports.
You're doing where I'm missing it out. Where?
Page 27.
Page 27, I'm there.
Put that advertisement start from page 24.
No, yes, I'm at page 27, but where you are reading?
My lord, serial number 5-6. Page
A
27.
certificate in recognized sports representing Assam officially at national level 10.
And then achievements in fine arts.
Achievements in fine arts, cultural activities representing the state officially at national level.
Yes, my lord.
Yes, where is your,
Well,
where you have done that?
From page 83 onwards, 82 onwards,
82 onwards,
182 onwards.
182.
Yes.
These are all certificates he is attended in his personal capacity, not representing
All
state or
India-
national.
all India then
That will not get it.
Yes, Lordship.
Sangit Natak Academy.
I can only issue a notice because I can't give you an interim relief. As
Yes,
per law, but I'll issue a notice.
I'm not paying for interim.
Okay, okay.
Only for consideration of my certificate.
If notice would go ahead.
Mr. N. Sharma and counsel for the petitioner. And Mr. S.M.T. Chistil for the School Education Department,
1 and 2.
representing respondent numbers 1 and 2.
Yes.
It could be petitioners as petitioners. 1 and 2. Next, para. You shall notice a motion returnable in. This is recruitment process. We'll make it 3 weeks. I think you can respond in 3 weeks.
Yes.
Similar
Return in 3
matters.
weeks.
Similar two matters are coming on 25th. Similar matters submitted by.
On
separate-
25th, they will not be able to file the response.
Yes.
Because, if any order is passed in 25, this will cover this
Yes,
matter.
Yes.
As the organic standing accepts notice for respondent numbers 1 and 2, requisite extra copies of the revision be served on him within in course of the day. Next para. What is the post for which you are applying?
LP school teacher.
Hmm?
LP school teacher.
LP school teacher, assistant teacher, okay. As the petitioners are aspirants for the post of assistant teacher in
LP
LP schools. The authorities in the school education department shall file a timely response.
Yes.
List after 3 weeks.
Yeah. That is.
If we get 10 extra marks, then we'll cross the cutoff mark. That is our given.
Oh, Asha, you have, okay. No, I get it, but you see, eligibility criteria must be met.
Yes, consider my our certificate.
You mean otherwise good in sports, but it has to be what you call as per the advertisement, because the question I asked in the last case, you see, how can you be treated differently? Because if you are to be treated, others should also get an opportunity of competing with you.
And there was a committee lawsuit constituted by the government lawsuit to look into all this, verify all this.
The pendency shall not be a bar to consider my pendency shall not be a
They
bar
will not-
to consider.
They will not appoint.
Yes.
They will not appoint. I
They
can
will
know.
appoint my lord on 25th.
No. What is the prayer, Mr. Sharma?
My lord, our prayer is for considering our certificates of experience, the certificate of sports and culture. If we get extra marks as per our certificate, then we can cross the cutoff marks fixed by the departmental authority in the provision.
But their case was not considered at all.
No, Mr. Sharma, you see, there lies the problem. If I ask that this case would not be a
Bar.
bar for considering your case, that means you are the court is carving out an exception for you. Other similarly situated persons, there may be someone who may be equal sportsman like you, so they will be deprived of doing it. We can only mention that the pendency of the writ petition.
No, in other cases, there is no interim order.
No, I'm not passing an interim order. The pendency of the writ petition shall not be a bar for the respondent authorities. Consider the claim of the petitioners with all equally.
Now, because provisional list has already been outclosed.
No, it should not be a bar, I am saying.
Yes.
It's not a direction to consider.
Yes.
All similarly situated, along with all other similarly situated persons.
Highly apply.
This is not a direction, it's only a, it's not a bar.
Right, what was it, right?
আচ্ছা
Private company.
আরে দিলে এজনো না পাব অসমৰ পৰা কোনজনে পাব ইমান এটা কেইজনী আছে ইমান আছে এপ্লাই কৰিব নেকি তাৰ পাছ কৰিব নেকি নমস্কাৰ এই নম্বৰ Item 9 dismiss কৰিলে withdraw কৰিছে Item 9 withdraw কৰিছে আর ইসলাম এখানে withdraw কৰিছে dismiss as withdrawn
तो दस्ती है ना जो दस्ती है वो आपको ऑफिस में जाना होगा आरण्य काउंसिल रिटर्न निकल करके एक लिखा होगा पहले पन्ने उसमें साइन और सील करना पड़ेगा अभी केस अभी लास्ट डेट पे इसको दिखाना होगा अभी जो बात करना है ऐसे मत करके रूप सो दे फोटो मार दे नहीं हो जाएगा तो हम उसको करेंगे सरकार এইটো যে আপুনি আপুনি খাই আছে ঘৰটো গম কালি ৰাতিতে উঠি জনে যদি 20 খনত যদি মানে চালে ভালকে এইবিলাক নহলে সেইটো কেছটোহে আহিব লাগে এখন চুৰানা ছাৰ কোড আজি নাই আপুনি ঠিকে ধৰিছে অলপ লাইনটো কি কৰিছে জানে কি ভাবিছিলে মুনটো আহিলে সাবমিটে এই সাবমিট দিছে ই মানে মেইন লিষ্টখন চোৱা নাই ডেইলিখন চোৱা নাই এইটো নিজে নিজে ডেইলিতে আহি আছে আৰু আমাৰ যে মেনশন মেমোৰ মতে নাহিবও পাৰে ন এইটো ইনে নিজৰ হেনা আহিছে আৰু ডেইলিতে আহিছে মানে এসব সামনে বলতে সাবমিট ছাড়া তো হি পালে কারণ মানুষের তো সাবমিটে যাব কারণ সাবমিট করে এখানে মানে আর যদিও রেজিস্ট্রেশন হয় মেনশন মেমো নহলে ইনি নিজে নিজে রেজিস্ট্রেশন মানে কেসটো আহি গেছে লাইন মেনশন দিলে সোনকাল হব কাৰণে দিয়ে কিন্তু কেসটো মানে অলরেডি তার পাল কৰিছে এখন কৰিছে উকিলজন যদি কাইলৈ ভালকে ৰাতি 25 খন চালে এই বস্তুটো নহয় আৰু কিহতে মানে বস্তুটো এনেকা লিখিছে নাম্বাৰটোৰ লগত একটো লাগি আছে
Malat, yes, Malat, it is earlier rejected on 11th of August 22.
Yes,
Malat, I have gone through the case, but it is Malat, after the 11/8, Malat, earlier office note was Malat, IO note was about 29/7. Subsequent is Malat 9/5. Only when Malat that honorable court asked for the Malat certified Malat case diary. Then only Malat. And I was said that he was not found in the room, my lord. He is searching. Only that much, my lord, nothing, my lord. Nothing progress, my lord, in the case. My lord, here is the last note, my lord. I flag my lord. Otherwise, my lord, earlier, my lord, there are statements of the witness, my lord, because of their mental torture, my lord, she commits suicide. FSL earlier, my lord, PM report and the subsequent FSL also, my lord, proved that, my lord, by consuming alcohol, my lord, poison, my lord, commits suicide. Only last note, my lord.
no, I'm looking at something else. The Viscera report is not there still.
My lord.
Viscera report is not there. It's Vijay, I'm unable to get. How was the that girl taken to the hospital?
My lord, that much I have not.
As per FIR, your lordship, the petitioners taken the girl to hospital.
Petitioner took. Where is that? They will give them bail if they have taken the girl the lady to hospital.
All of it. He is the husband, yes. But Mr. A.R. Karim then counsel for the petitioners. And Mr. K.K. Parashar and APP for the state. Next one. The petitioners are apprehending arrest in connection with Agumani PS case number 79 of 2022, page 1. They paid for pre-arrest bail. As per the previous application for pre-arrest bail was rejected by order dated 11/8/2022, passed in AB 1824 of 2022. Next one. Prayer for bail is objected to by the General APP by producing the case diary, and it is submitted that no new grounds have been made out. Next one. On examination of the case diary, the investigation carried out so far indicates that the victim had consumed the victim had died of poisoning and the toxicology division of the Director of Forensic Science indicate that the viscera gave positive test for organophosphorus insecticide. It is there in the previous order spelling. First one. On a perusal of the inquest report, it is so that there is no mark of violence in the body of the deceased. And it is also observed that as per the FIR, it is the petitioners who have initially taken the victim to the hospital, where she was taken. Which place she was taken? Yes.
To Agumani CSC. On 25/5/2022, And in course of treatment, she expired on 26/5/2022. First, in view of the conduct of the petitioners to take the victim, who is the wife of petitioner number 3, to hospital for medical treatment immediately. Notwithstanding that the previous application for bail was rejected by order dated 10/8/2022. Court is inclined to release the petitioners, namely so and so, on bail on their furnishing bail bond of rupees 50,000 each, with an surety of like amount to the satisfaction of the arresting officer. There is granted on the following conditions. Due to those conditions, they will all appear before the IO once within 10 days from the date of the order, and thereafter they will continue to appear once every 15 days till the personal appearance is dispensed or charge sheet is submitted. As per the petitioner shall not leave the jurisdiction of Agomani police station without intimating to the IO. Is that application disposed of?
Well,
Yes, you are ready now? Tell us.
I apologize, I was supposed to.
No, let her do it.
Very convenient.
She'll continue. Yes,
My lord, matter relating to non-selection of the petitioners of the post of library bearer.
okay.
On 24/12/2022, the principal of Secretary Silarai College, Golagans, published an advertisement inviting applicants for filing up of the post of junior assistant unreserved grade 3 post 1 and grade 4 post 3 library bearer reserved for OBC, MOBC and 2 unreserved.
Yes,
Is in page number 16 annexure 3.
page
16 annexure 3.
yes.
The candidates applying for the post were directed to appear in the examination which was held on 18/4/2023.
Yes,
The petitioner also appeared in the examination written test, which was based on multiple choice question along with OMR sheet. In the OMR sheet, the serial numbers were handwritten and same were checked manually. On the other hand, the skill test was conducted by some unrecognized and unqualified person who work in the nearby DTP centers. The respondent authority was yet not declared the marks of written test, skill test, and viva voice, and directly declared the result of selected list. And also private respondent was seen to have submitted blank or MR sheet, but on 18/4/2023 itself told everyone, she herself told everyone that she got the job.
okay. What's your name?
Sanjima Narzani.
Yes, Ms. Nazari, what is the status of this college? It's a government college, provincialized college, or what you call private college? What is that? What is the status of the college?
Provincialized college.
Provincialized college. Then we issue a notice,
Notice.
and the whatever appointments are made, it will be subject to outcome of the
Yes.
deliberation. Okay. Third, Mrs. Nazari, counsel for the petitioner, And Mr. S. Bhuyan and standing us for the Higher Education Department,
1 and 2, Lordship.
appealing for respondent numbers 1 and 2. By alleging that the respondent number 6 was illegally selected for the selection appointed to the post of library bearer within bracket grade 4 in Chilarai College, Golagganj. This writ petition has been filed under Article 226 of the Constitution of India to challenge the appointment of respondent number 6. Issue notice of motion returnable on 4 weeks. Requisite extra copies of the writ petition be served on the 11th standing house for respondent numbers 1 and 2. First off, the petitioner shall take steps within 2 days for service of notice on the respondent numbers 3 to 6 by registered post with AD. First off, the petitioner is at liberty to collect the postal receipt. The Learned Counsel for the petitioner is at liberty to collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next paragraph. Court is inclined to provide that taking note of the contents of complaint dated 2/5/2023 within bracket annexure 7. The court is inclined to provide that the appointment of respondent number 6 shall be subject to outcome of the petition. Yes. So next time when you are appearing in the court, always be prepared, right? No adjournment on ground of senior.
Please, my lord.
Yes.
Matter pertaining to provincialization of 2 schools. My lord would kindly come to page 16 of the writ petition. My lord, I am an employee of the Ishwar Chandra Vidyasagar School. And our school has been merged along with number 2 Maharanipur LP School. And the Maharanipur LP School has been made the base school.
Watch. Yes.
My lord. My lord would kindly come to page 16 of the writ petition.
Page
1616, my lord.
Okay, we're issuing notice at this stage.
My lord.
He's asking that school to be a base school.
My lord.
You are Mr.
PR, sir.
Counsel for the petitioner. And Mr. P. Sharma, P. Baran, standing counsel for the School Education Department.
1, 2, 3, 4 and 5, my lord.
Okay,
6, my lord, notice may go.
okay, 1 to 5.
My lord.
Filing this writ petition under Article 226 of the Constitution of India, the petitioner claims that which school?
My lord, Ishwar Chandra Vidyasagar ME School.
Ishwar Vidyasagar LP School should not be merged with number 2 Maharanipur LP School as base school. What is the reason you are assigning?
My lord would kindly come to page 22 of the writ petition, and the effective portion is in page 24.
Yes,
This is a finding by the district elementary education officer, which they have submitted to the director of elementary education. My lord, here it is stated that the remark, there is no any upper primary school within the radius of 7 kilometers. Now, as per the recommendation of the Honorable MP Lakhimpur Lok Sabha constituency, the venture school has prayed to consider their school as the base school. My lord, there is no other school, upper primary school within 7 kilometers. As such, my lord, we are squarely covered under provision 6 subclause 4 of the Assam Provincialization Act. If I may take my lord to that provision.
There is a committee, my lord, for regarding.
just let me understand what he's trying to say.
My lord, if I may read the said provision. The government of Assam shall identify base school for the purpose of provincialization of services of teachers of the venture educational institutions, so as to fulfill the norms and standards required for providing educational institutions within a specified area as follows. My lord, section 6A subclause 2, at least one upper primary school within a radius of 3 kilometers. Now, my lord, subclause B says that if any provincialized school already exists within the aforesaid radius, the existing provincialized school shall be identified as the base school at the exclusion of a venture education institution. My lord, now, my lord, as per the remarks of the committee and this proviso, my lord, we are praying that there is no other school within 7 kilometer radius. As such, my lord, it is important that the institute remains as a self school, my lord. If it is merged with the other school, the Maharanipur school, then, my lord, the students have to shift, everything has to shift. Then, my lord, there will be a lot of problems that the students will face, my lord. That is our basic remarks. We are already having 140 students in our school, my lord. Good enough students.
You tell us, how do you lose any benefit?
My lord, what will happen is that if we go there, if I may take my lord to the base school order, page 16.
No, you don't agitate about anything else. Your own right.
My lord, I will be designated as a tutor. Right now, I am a headmaster in my parents' school. That is the Ishwar Chandra Vidyasagar ME school. Then there will be a downgradation on my part. I will be designated as a tutor. If I may read the definition of tutor, my lord. Tutor means and includes teachers, assistant teachers, classical teachers, and also includes lecturers, assistant professors, etc. Under this act, who are not eligible for provincialization of their services and whose services cannot be provincialized in the post of teacher under this act due to lack of his or her eligibility. My lord, this is in definition.
It is claimed that if the school is merged with another school, the petitioner would who is now an headmaster of the school will be downgraded to that of a tutor, and he may not be eligible for provincialization. It is also submitted that as per the report of the district elementary education officer Dhemaji, there is no upper primary school within a radius of 7 kilometers. Accordingly, we submitted that the proposal for merger would be against the policy of the state. Next, you should notice returnable on so. Requisite extra copies of the petition is served on the running. Standing counsel for the school education department for respondent numbers 1 and 2. No, so 1 to 5.
My lord.
Next, the petitioner shall take the steps for service of notice on the respondent number 6 by registered post with AD, as well as by routing the process through the registry of the court, and upon service and affidavit of service certified prior to the next date of listing. The decision for amalgamation in respect of the school of the petition in question shall be subject to outcome of the petition.
I have produced a notification. There is a committee regarding amalgamation.
The next para, the pendency of the petition shall not be a bar for the respondent authorities to refer the matter.
But
for
they
a-
have to approach the director.
So you can do it. You can send it. It shall not be a bar for the respondent authorities to send the
Committee, my lord, I have.
to send this matter for a re-verification by the re-verification committee constituted wide. Order number E 225754/1 dated 10/9/2022 issued by the Secretary to the Government of Assam, Department of School Education. Next paragraph. In view of the contents of the said order, dated 10/9/2022, the petitioner is also at liberty to move the amalgamation of the merger re-verification committee, which is constituted of the following members. Number one, Sri S.N. Das, Joint Secretary to the Government of Assam, within bracket Chairman. Srimati Anuja Bhuya, Deputy Secretary to the Government of Assam, Member Convener, Director Secondary Education Member, Director Elementary Education Member, System Analyst, SSA Assam, Technical Member. You send the representation, they will close on the next date.
Highly obliged.
If there is a notification for re-verification committee, correct? Next time we are giving you liberty.
6.
We're giving this, let him type it out.
Obliged.
Obliged.
6.
Yes.
My lord, I was not aware of this case. Actually, I was not served with the copy. That's why.
No, that's why we give you notice.
My lord, my lord.
You,
My lord, I have gone through the thing, my lord. Now the thing is that if you go by this page 48, the order of this honorable court order, my lord, idea order of a coordinated bench, my lord. So it was sent to the court. Ultimately, my lord, the status of the children, my lord, has to be decided by the committee. Whether the DC did not.
no, the
issue-
requirement is that DC must countersign it.
Yes.
If it does not sign, what can the person
My
do?
lord, that part, my lord, why DC did not sign, I don't know, my lord. But if I go by this page 50, that my lord, earlier order of this court, my lord, I'm just
Yes,
referring to this, my lord. Page 51,
yes.
this G. Pego such and such, he got from.
Provisional admission.
Yes, my lord, provisional admission. And in the meantime, my lord, this was sent to the committees so that they can take a call, my lord. They will examine the thing and whether
Which committee?
that state level scrutiny committee, my lord.
No, you see, there is a difficulty.
My lord.
Mr. Dhawal. You see, nobody is challenging that certificate, correctness of the certificate. They are not accepting it just because the deputy commissioner has not countersigned it.
My lord.
Correct. So why should I make the petitioner subject to verification process when the correctness of the certificate is not in the challenge?
My lord, here then, my lord, DC has to explain why he did not,
Why is not signing it?
my lord, here then, I will request some of my friend to appear, because here there will conflict of interest with me. If I appear, state level scrutiny committee WPT is a party here in this case.
if I appear for vote and
I understand.
I'll
You will record whose name?
my friend is appearing my lord, for DC.
Okay. Because you must tell us why you are doing it.
My lord, that is the board, my lord. Board have to place before the DC. And why their control sign is not there, my lord, that's part I have to obtain inspection.
Only that much you require.
My lord.
Because if the association is giving a certificate, as per rules, the deputy commissioner has to countersign it.
My lord, that is the mandate.
That is the requirement. So we are issuing a.
Even their observation also correct, my lord, that DC signature is not there.
No, correct. So we'll list it next week, you get an information.
My lord.
Uh, for Mr. Aradil and counsel for the petitioner. Mr. Uh, the authorities of the Jawahar Navodaya Vidyalaya Samiti has not accepted the caste certificate issued by some other backward classes after that apostrophe association which is issued by one Madhavi MADH Pandit, President of OBC Association, West Karbi Anglong, Hamren, as the said certificate was not countersigned by the Deputy Commissioner, West Karbi Anglong. First of all, it is projected that the son of the petitioner the petitioner number 2, who is now 12 years and is an aspirant for admission to class 9. And the documents were to be submitted. On or before 12/5/2023. And so it is submitted that if the caste certificate with countersigned by the Deputy Commissioner is not produced, there is every likelihood that the candidature of the petitioner number 2 may be rejected. Who will be appearing for this? Navodaya Vidyalaya?
They have studied.
Usually the CGC they appear. The last occasion, so far I remember. Kanish Gupta appeared once.
Now this matter.
You have served copy on them.
CGC.
I got to
Respondent number 1, my lord. CGSC, my lord.
Is the name reflected in the cause list?
Deputy solicitor.
Name is appearing. Just say DSGI. DSGI only CGC. Accordingly. This petition has been filed in Article 226 of the Constitution of India. Next one, issue notice of motion, return of allowance. Just leave the gap, the date gap. So and so. Requisite extra copies of the petition be served on the learned State and Department Council appearing for the appearing respondents. This caste level scrutiny committee will be by whom you, by you.
Seven, respondent number seven.
Just say that. Mr. P. Sekia accepts notice on behalf of respondent number 3N. The Deputy Commissioner number 3. No, not 3.
Probably this is my.
No, 5. Okay.
I am only 5.
For 5. And Mr. R. Dhawal, standing for the WPT and DC department, accepts notice on behalf of respondent number 6. Mr. Dhawal, you'll be for 6 only then.
7,
Here's 6 and 7.
7, 7.
6. No, 7 is caste level. Acha, 6 and 7. 6 and 7. Let us use the appearing for CGC. Yes, so and so text access notice on behalf of respondent numbers 1 to 4. Next paragraph. The learned government advocate shall obtain instructions from the Deputy Commissioner West Karbi Anglong as to why so their petitioner number 1 and 2 both are minor. For both of them, this petition is fine. So why the said authority is not countersigned? Where is your certificate? Page?
It's 8,
Page
18, my lord.
18 has the signature.
Lost it.
Then,
This is my lord, father's my lord.
and where is yours? We are concerned with yours. Where is that?
24, 25. Student page 24 and 25.
Why, despite the fathers of petitioner number 1 and for the petitioners having OBC certificate, the countersign was not made in respect of the OBC certificates of the petitioners. Full stop. The pendency of this petition shall not be a bar for the Deputy Commissioner West Karbi Anglong within bracket respondent number 5 to countersign the certificate, OBC certificate of the petitioners within bracket
If it is found in order.
respondent number. Sorry. And it's just 6 and 7. If the OBC certificates of their respective fathers within bracket being connection 1 and 2 are still valid.
If I go by this page 24, my lord, here also I don't find this countersigned by the DC.
Which one?
Page 24, the certificate.
No, that is what is saying. This is not signature.
24.
But the fathers, the signatures are there. Next one, the in the interim, it is also provided that till the next date of listing, the respondent numbers 2 and 3 shall provisionally admit the petitioners in their school if the petitioners are otherwise have otherwise secured their admission on merit. Next part, the petitioners are permitted to produce a certified copy of this order before the respondent number 3. Respondent number 4. It should be. The direction would be as 2, 3, and 4 to admit, provisionally admit, and certificate copy will produce before respondent number 4. Just wait for some time. Let the CGT come. Who's I think I don't know. Just wait. Don't go.
Otherwise, my lord, in earlier matter, GPEGO appeared. My lord may recorded his name. I will inform
No,
you.
because I have to tell you, Mrs. G. Pego.
GPEGO.
Okay, right, Mrs. G. Pego. Please inform me.
My
because you
lord,
have to
I'll
communicate.
inform.
The
And,
Ladat CGC shall also communicate.
And
Download a copy of this offer to the concerned authorities.
requisite copy may be furnished to him also.
I'll find it.
Master.
Give it in course of day to day.
Lordship.
Don't delay.
My lord, fix it after 3
Let's-
weeks.
After 3 weeks.
Master.
Okay.
It is, my lord. Matter
Yes.
my lord, similar matter of provincialization of school, my lord, to the base order. My lord,
Same.
my lord, but my lord, there is a difference. My lord, may kindly come to page 13 of the writ petition.
Yes.
Herein, my lord, our school was only made the base school. The Sahabari, pointer number 1, my lord, the Sahabari Kalia High School is identified as the base school. For this school, the concerned teacher tutor will have to join in the base school and he or she has to perform his duties. Now, my lord, what has happened is that if my lord comes to page 18 of the writ, 118, my lord, 18 of the writ petition, my lord would see that we have come to know that one Jamuguri Panchali High School is going to be merged with us. That is why we have requested the authority concerned to kindly allow us to keep our self-school status. The status we are enjoying currently, so that we continue enjoying it. We have made another representation before the Director of Secondary Education. And
That can't be permissible.
my lord,
That can't be permissible.
my lord.
That would be against the policy decision. How can you choose that what status you will maintain is a provincialized school? When you are personal status is affected, I understand. But this challenge would not be maintainable.
My lord, if I may take my lord to page 22 once,
Yes.
just once. My lord, regarding for self-school for Sahabari Kalia High School, my lord, here we have written to the Honorable Director of Secondary Education that we are having 152 number of students, then our facilities, etc.
No, you can't take a decision for yourself.
My lord,
You can't take a decision for yourself. We will not permit that. So then everybody becomes a self-government. Every institution becomes a self-government, local self-government. That will not permit. This requisition I am dismissing.
my lord.
You have anything to say, Mr.
There are no grounds to entertain it. Actually.
Okay. Heard Mr. D. Medil, PR Sharma and counsel for the petitioner. And Mr. R. Mazumdar, understanding counsel for the School Education Department, appearing for the respondent numbers. You'll be appearing for 2, 3,
2, 3,
4, 5,
five.
6.
1 minute.
2 to 6. And Mr. P. Sekar and Government Advocate appears for respondent number 1. In view of the order proposed to be passed, issuance of notice on the respondents is, including respondent number 7 is exempted. Next, madam. the petitioner is an employee. So what is the status of employment? What status?
Headmaster. He is the
Is he-
headmaster and respondent number 7, Lordship will see is the headmaster. Not a very. conducive assessment.
No, that's okay, because he's an employee of Sahabari Kalia High School, different school.
My lord,
That's why.
my mistake.
I know it's okay.
I'm sorry. My mistake.
The petitioner is the headmaster of Sahabari, Sahabari, Kalia, Kalia High School. The as per the policy decision of the state, comma, the school of the petitioner was selected as a base school, and it was proposed by the authorities that Jamaguri Panchali High School, JMUGURI, Panchali PNCHRI High School, would be merged with the school of the petitioner. Full stop. Agreed by the proposal, the petitioner has submitted a representation dated 31/8/2022 to the Inspector of Schools for keeping the self-school status of Sahabari Kalia High School, followed by another representation dated 1/3/2023. Next, the learned counsel for the petitioner has submitted that the school of the petitioner is having an enrollment of 152 students. With sufficient teaching and non-teaching staff. It is also submitted that there is no other school within 8 to 9 kilometers around the school of the petitioner, which will disturb the school education environment. Full stop. Accordingly, this petition has been filed under Article 226 of the Constitution of India to assail the decision of the government to for the merger process and for direction upon the respondent authorities to retain the self-school status of the petitioner. Next para. It appears from the contents of representation dated 31/8/2022 that the school managing committee, the president of the school, its president or Sabhavati is chairman. What is it? Sabhavati English would be what? President or chairman?
President.
President. Okay, president of the school managing committee had represented before the supervisor of schools from Dhemaji district to permit that to facilitate Chahabari, CHAHBARI, Kalia High School, Secondary School, to teach in our school, to teach in their school. Full stop. As for the contents of the representation dated. What is the date of the second representation?
My lord, 1/3/2023.
1/3. Where is that date? It's nowhere there.
My lord, top right corner of the page. 1/3/23. Page 22 of the representation, my lord.
1/3/2023.
That is the first representation.
The first representation is by school committee. The second is, I think, has no date.
There is no date.
Where the contents of this second representation. The representation submitted by the petitioner. Comma. The petitioner has opposed the decision for imposing other English medium school on them. In the second representation of the petitioner dated 1/3/2023. The grievance of the petitioner was that the students would be if their school is merged with Jamgori Panchali High School, the students would feel harassed. And most of the students would have to walk a long distance for their schooling. Next paragraph. Court is constrained to hold that all the grounds for which are mentioned in the said representations are not good and sufficient grounds to challenge the administrative decision of the authorities of the school education department to merge the school of the petitioner with another school. First, the court does not find that does not find any merit in the representations, and therefore this is not found to be a fit case for issuance or notice on the respondents. Full stop. According to this representation stands dismissed in Lebanon without issuance or notice on the respondents.
Highly obliged.
Yes, next. Yes,
May I please the lordship? Lordship. as
you got
per-
the instructions?
Yes,
sir.
we have received the instruction from the school inspector of schools, and as per inspector of school, formal proposal for inclusion of the name of petitioner. Petitioner in the amalgamation order of Bipin Bora School with the Bipin Bora High School, and including the proposal of regularization of the lip period has been forwarded. And my
You-
lord, in the meantime, my lord,
Director Secondary Education wrote to the Secretary to the government for issuance of necessary instruction on the matter of inclusion of the name of and regularization of the service in respect of petitioner.
Show me that letter.
Yes, ma'am.
I could not follow that content. Miss
P. Sharma.
T. Sharma and counsel for the petitioner. Next, pursuant to the order passed on 2/5/2023, comma, the London Standing Council for the School Education Department. Mr. U. Sharma, counsel for the has produced a copy of letter dated 18/5/2023, by which the Inspector of Schools, Tinsukia District Circle, had forwarded a formal proposal for inclusion of name of Srimati Barnali Fukan, assistant teacher, in the amalgamation order of Bipin BIPIN Bora BURA ME School with Bipin Bora High School, and for regularization of her leave period. As per the details contained in this letter dated 18/5/2023, leave grant orders orders are reflected against leave period from 3/10/2006 TO to 6/11/2000. In the first column, the numbers did so and so. First column in 2019. First column. There's something wrong, Mr. Sharma.
My lord,
Something wrong.
my lord. No, this letter is, my lord, in response to my lord Inspector of Schools report, along with and to the letter number ISTDC Miss 604/2018-674 dated 2/5/2023.
But that letter is not here.
My lord, director, the letter issued by the director, it is stated here, my lord, in the.
No, I understand,
next-
but that letter is not here.
Oh, yes.
Poster. The Learned Standing Post for the School Education Department has also submitted that the Director of Secondary Education, Assam, has also moved the government to issue necessary instructions in the matter of inclusion of name of the petitioner and regularization of leave period of inner service. Which was made by communication dated 15/5/2023. The instructions produced are retained as a part of record. You have copies of this?
Yes, ma'am.
You make photocopies and give it to the court master.
Yes.
We don't need the entire bunch. Give the relevant part only.
Yes.
Only that one, these two letters
Yes.
and this letter 2/5. Only these three letters. Expecting decision of the appropriate authority of the government, comma, the matter is deferred today. List on. Give after 6 weeks a date.
28/6.
Just before the right, the pendency of this petition shall not be a bar for the competent authorities in the field of school education and the Director of Secondary Education Assam to take an appropriate decision for regarding inclusion of the name of the petitioner in the amalgamation order and for regularization of a leave period of service. Regulation for service for the leave period. Give copies to the court master, right? We're adjourning it. Let us see what is happening. Yes.
20.
Yes.
My lord, the very outgo.
You are both a friend and a government.
Lordship.
Mr. Nair,
Lordship.
you are both friend and a government. Two things can't stand together.
Mitra Sarkar. It cannot, my lord. The facts also are like that. My lord, what happened is, in this case, is that the petitioner was initially appointed as an honorary teacher in a provincial high school. My lord, the decisions are there. It says, my lord, in a provincial high school, an honorary teacher cannot be appointed. True, my lord. But the government, my lord, regularized her services. And therein, my lord may have the appointment at page 19. I'm on a very narrow campus, my lord.
Who's appearing for the
Government, my
Correspondence?
friend will appear. Elementary would be Victor. Elementary has filed an affidavit. Then, my lord, this appointment was, my lord, at page 21.
But you see, Mr. Nair, this every time this Uma Devi crops up.
No, I'm not on Uma. My lord, need not even go that far. There are decisions of this honorable court which says that in a provincial high school, you cannot have a honorary appointment. Honorary would be in a, my lord, prior to that.
But your second statement that the service was regularized.
No, it was adjusted by the authorities. And my lord, my limited prayer now, I went for a title suit, dismissed, appeal dismissed. But my lord, those were not maintainable. But be that as it may goes, my lord may come straight to my lord. This is my area of concern. My lord. Page 116.
116.
Lordship. My lord, a show cause notice was issued to her under Rule 9, my lord. My lord has got it.
Yes, yes.
A show cause notice was issued to under Rule 9, saying that you're an honorary teacher, illegal. Then, my lord, another thing that when the day I joined, I was around 15 years. in the year 89, which is considered as underage, but she actually joined in 1993. Be that as it may, my lord, thereafter, my lord would find an order at page 120. After saying everything, my lord, the last paragraph. After careful consideration and perusal of the records and having regard to the evidences appearing in this case, and in pursuance of the order or government letter dated so and so, the service of so and so who was appointed and regularized the service irregularly and illegally as so and so against non-existing post under district elementary education HR is hereby terminated with immediate effect. Now, my lord, let's see what they have done. Page 120. The service termination order of so and so under the district elementary education officer Kachar issued by the what happened exactly after this? Well, neither they are allowing me to join the because by this time the school got amalgamated. I was in the elementary section. It got amalgamated with the high school. Now, if you have proceeded for an inquiry, you had an inquiry report, and thereafter, my lord, you terminated my services and you withdraw it. This cannot happen. This is my area. If you wanted to examine the matter, you examined it. Then you follow the principles of a proceeding which is to be followed.
Cancel means that your termination is withdrawn.
Withdrawn, my lord. So I should be continuing because there is no order other than that removing me from my services. My regularization stands now. Nobody has come and challenged that before your lordship.
Yes, Mr. Mazumdar.
Give me the affidavit. This apparently an
I think I'll have to give you a few days. Few minutes will not settle it.
if you have health vision, you have health vision, either cancelled हो ये discussion देखो then why can this order is
And
So,
in the affidavit
You
file,
have a worthy second name.
Sarkar, my lord, in the affidavit that has been filed,
No, I understand.
this has not been denied.
No, even by reading your petition, I could not understand what this is what you are trying to say.
This is the only point.
No, but why so much of things I couldn't understand reading this. What is happening?
I also have not gone into the other things. One of the other things are just to make it a case. One of the facts have been stated. That's all. But the issue lies there.
You see this, what do you call that? By reading this, it could not have been understood. No.
I understood. Madam. I couldn't decipher. Madam. I only deciphered those portions.
Your pleading is state like a jalebi.
My friend will understand.
I don't know. I don't know. That is.
My lord, no, my lord. This is direct.
No, but you see, the point is very simple. If I don't understand, I don't give an order.
No, my lord will understand now that
Now-
the last
now-
3 pages, my lord.
Now you understood.
Only the 3 pages.
I don't understand, no order.
No,
Okay, but I will give you time, Mr. This has to be addressed.
yeah, my lord will direct the elementary
No,
department.
I will make my order clear. Her Mr. UK Nair as senior counsel, assisted by Mr. M. Khan, counsel for the petitioner, as well as Mr. R. Mazumdar, known as standing counsel for the school education department, and Mr. A.K. Datta, learned counsel for respondent number 8. Next para. The learned senior counsel for the petitioner has submitted that his writ petition is in a that his submissions would be confined in a very narrow campus. Stop. He submitted that pursuant to departmental proceeding initiated against the petitioner, comma, by holding that the petitioner was appointed and regularized in service irregularly and illegally as assistant teacher of Tarapur Girls ME School against non-existent post under the District Elementary Education Officer Kachar. Her service was terminated with immediate effect by an order dated 21/4/2011 passed by the Director Elementary Education Assam. By referring to an order dated 28/9/2011 within bracket annexure 22. This just a moment. This earlier order of 21 April 2011 within bracket right annexure 21. Now the second order thereafter by order dated 28/9/2011 within bracket annexure 22, comma, the previous order dated 21/4/2011 was cancelled. Thus, comma, it is submitted that if the termination order of the petitioner has been cancelled, comma, the petitioner would be entitled to all benefits pursuant to the regularization of her service. It is submitted that in the meanwhile, the school of the petitioner has been amalgamated with another school.
It's called Tarapur Girls ME School is the petitioner school. Now the amalgamated school is Tarapur Girls High School.
With Tarapur Girls High School. And that despite the order dated 28/9/2011, comma, the petitioner has not been allowed to join her service. Next paragraph. Although the school education department has filed an affidavit in opposition through respondent number 4. But the issue raised by the learned senior counsel for the petition has not been addressed. So accordingly, the matter stands adjourned to enable the school education department to provide appropriate instructions to their learned standing counsel or file additional affidavit if so required. List on 26.
261.
You'll do it by 26 or we make it 56?
5/6. 5/6.
56.
What is intriguing me is, my lord, the two orders are placed on different files. That is not usually done. But that is what is intriguing.
That's why the second name in short.
Yes. Mitros also.
So Mr. Nair, without knowing the facts, I got the correct words. Interpreted the words correctly.
100%. 2 words, Mitra Sarkar. And it can also mean, my lord, a joint Sarkar.
Yes,
Make the lordship.
yes.
In this case, lordship, I am for respondent number 5, lordship. Earlier one 14/3/2022,
And you are
From the-
conceding to the prayer.
lordship.
You are conceding to the prayer.
Lordship, no, I am on that lordship. They have already, I received one notice from the government lordship that the hearing was taken place by the director.
Oh, is
on
it?
15th. So I pray lordship let 2 weeks.
You show it to Mr. Segia. Show it to Mr. Segia.
আমার hearing করিবে। Notice দিন। My lord,
It's okay, we'll not
I'm
burden this.
continuing lordship, but I am not getting salary lordship. I am arriving teacher lordship.
No, we can't do anything, but we can
2
only
days
adjourn
cannot
it.
be lordship, let the matter may wait for
Yes.
1, 2, 3 weeks lordship.
This letter doesn't show that whether the petitioner was called for a hearing or not. No.
I don't know what this is, what he's producing.
Only addressed to my management's client, my lord.
All sides are duly represented. Mr. K. Mazumdar, counsel for the private respondent, submits that the said respondent is in receipt of a notice
Lordship.
to appear in the, just don't give us, just tell us.
On-
the notice to appear in the.
I appeared on 15/5/2020.
Hearing to be held on 15/5/2023. First of all, Mr. Sekar, I. Sekar and counsel for the petitioner submits that from the contents of the said notice. It is not clear whether the petitioner was called at the hearing. First of all, next, be that as it may. As purported hearing has taken place before the state level committee.
Lordship, it was issued by the Director Elementary Division Assam.
Okay, by the Director Elementary Division Assam. The matter stands adjourned today to enable the petitioner as well as the respondent, the private respondent, to apprise the court of the subsequent development.
Led by learned friend Ken Lordship.
State petitioner will be directed to place the account the hearing petition.
So that's what I said.
Next date fixed.
That's why I'm saying that. According list on, how much time?
Lordship, my learned friend comment is their Lordship 2, 3 weeks.
Hearing has taken place.
It's okay, but when should I fix the matter?
We'll file an affidavit bringing all these things.
List after 2 weeks. In the meanwhile, the then it's Mr. P. Barar and his standing counsel for the school education department shall file an affidavit to bring his instructions on record.
Okay, fix a date.
Give a date after 2 weeks.
9/6.
Oblige me.
9, Lordship,
9/6.
9/6.
22.
Lordship, we please to see when your lordship's order date 21/12/2021. Authority are directed to file affidavit lawsuit. 21/12/2021.
But we wanted the disciplinary inquiry.
Yes, my lord, unfortunately, my lord, only yesterday I have sent them the read petition copy after collecting one from him. Could it be on the next week, my lord? Disciplinary proceeding.
So we directed that on the next day of listing, the respondents should either file an affidavit in opposition or ensure that the relevant records relating to disciplinary inquiry be provided to the learned standing counsel to show that there was no violation of the said provisions of the inquiry.
Perhaps some lapse on the part of the councils, my lord. The order and the repetition had not been communicated, my lord. I have done so
So
yesterday.
this, I think there's something wrong in the order also. There is something wrong in the order dated 21/12. Therefore, on the next date, the counsel of the petitioner submitted that so-and-so approval consideration was passed without compliance of mandatory provision of so-and-so. Therefore, on the next date of listing, the respondents would either file an affidavit in opposition or ensure that the relevant records relating to discipline inquiry be provided to the learned standing counsel to show that there is no violation. Okay, so you are required to get the records.
Right.
Okay. You want a week's time?
A week's time.
Mr. A. Dekhan and counsel for the petitioner is present. Mr. R. Mazumdar and standing counsel for the school education department. Submits that there was an inadvertent error in communicating the order dated 21/12/2021. It was sent only last week, correct?
Yesterday I sent.
On the yesterday yesterday was 18/5/2023. The praise fund is granted 1 week's time. To comply with the directions contained in order dated 21/12/2021. Next one on this one. 31/5.
My lord.
Because Mr. Dekha is claiming that the principles of national justice were not complied with. The procedure was not followed.
That is what, that is his allegation.
23. Yes.
Lordship, this matter relates to compassionate appointment of the candidature of the petitioner was not considered on the ground of time bar. Lordship, case 21 may be sent.
Page 21.
Yes.
You have instructions in the matter?
My lord, case of the petitioner, my lord, placed on initially 5/8/2014. That point of there is a no vacancy, subsequently 21/3/2015. That time also no vacancy, my lord. 4 times placed, my lord, on 18/6/2016.
Just
There-
on, just on. Mr. Sarkar is referring to page 21, where it was not recommended due to time bar.
Time, my lord.
This is, this page 21 is meeting dated,
Lordship, 21,
meeting dated
9/6.
9/6.
18/6/26, 2016.
18/6/2016.
18/6.
Yes, Mr. Saikia, which are the dates DLC was held?
My lord, first one is 5/8/2014.
Yes, what is there?
No vacancy, my lord. 5%.
Yes,
And second time placed on 21/3/2015, my lord.
same, no vacancy.
No vacancy.
Yes,
Again placed on 18/6/2016.
yes,
Then time bar. And 24/1/2020, my lord, again, my lord, why they have again. 24/1/2022.
now what this time?
This time, my lord, they're holding the decision of the earlier DLC 18/6, my lord,
Time bar.
time bar, my lord. Even second time, my lord, otherwise, why they have placed, my lord?
Yes, Mr. Sarkar. Then what can we do?
Lordship, on time part, Lordship, in this, Lordship, in this case, Lordship, on the last occasion, government advocate Lordship submitted, Lordship, within time he has not applied. That's time part, Lordship, yeah.
No, you see, that the judgment of this court. Achyut Ranjan Das makes it clear that if it can't be accommodated within a 2 years, it will deserve no further consideration.
Actually, Lordship, my case was placed.
It was other thing that it was placed, but there was no vacancy at that point of time. You could not have been accommodated anyway. The consideration would be the vacancy of the relevant year. So it is not
For
available.
our information, Lordship, for the first time, it was placed before the DLC on 16. And my criteria was not considered, that was not, I have not applied within time, Lordship, on that ground, Lordship. On the ground of not vacancy, not
So
available.
now Mr. Saike is armed with those minutes, 5/8/2014. It was considered earlier. Then we cannot reconsider it again. You shows that DLC minutes, earlier minutes.
My God.
Just note it down. Heard Mr. A.P. Sarkar, current counsel for the petitioner, and Mr. P. Saikia, learned government advocate appearing for the respondents. Next para. By filing this writ petition under Article 226 of the Constitution of India, the petitioner is playing for a direction upon the respondent authorities to place the name of the petitioner before the how many persons are there?
1%. Initially, we.
No, there are two people.
Yes, Lord. Initially, 2 persons we have filed, but 4 directed to file separate accordingly. Rishikesh, he is not in this case, but only for.
Where is that order? Which order?
Twenty-five for 22 parents lawsuits. I'm not sure. 25 for 20.
Okay, just not there. Before that. Next para, the learned counsel for the petitioner has referred to the order dated 16/3/2022 passed by this court. And it is submitted that that this writ petition was filed by two petitioners. However, by the said order, this writ petition was retained only in respect of petitioner number 1, i.e. Tripuresh Tripathi, and this petition was rejected in respect of petitioner number 2, namely Rishikesh Mishra, Rishikesh Mishra, who was given liberty to approach the court again. Therefore, it is submitted that although the cause title contains name of two petitioners, but he is pressing this writ petition only for petitioner number 1, Tripuresh Tripathi. Next further. In brief, the case of the petitioner is that the father of the petitioner who was working as a Sanskrit teacher in Mass MAZ Romari, ROWMARI High School, had died on 21/11/2013. And according to the petitioner, applied before the Inspector of Schools, Sonitpur District Circle on 9/6/2014 for appointing him on compassionate ground. Full stop. The claim of the petitioner was taken up in the DLC in its meeting held on 18/6/2016. And the candidature of the petitioner was rejected on the ground that it was time barred. First of all, the learned counsel for the petitioner has submitted that the application, as the father died, father of the petitioner died on 21/11/2013. His application made on 9/6/2014 cannot be said to be time barred. Next paragraph. The learned government advocate has produced the records and is received from the Deputy Commissioner Sonitpur, and it is submitted that the application of the petitioner for compassionate appointment was placed before the DLC on 5/8/2014, and the candidature of the petitioner was rejected on the ground that there was no vacancy. First of all, it is submitted that 5% of the vacancies could have been appointed on compassionate ground. The application of the petitioner was once again placed before the DLC on 21/3/2015, and the candidature was again rejected on account of no vacancy. Thereafter, the matter was again placed before the DLC meeting held on 18/6/2010, and the claim was rejected being time barred. Once again, the matter was placed before the DLC in its meeting held on 24/1/2022. So not 2010, it will be 16, 18/6/2016. Then fourth time it is 24/1/2022.
2020.
And once again, the claim of the petitioner was rejected being time barred. First, the learned government advocate has submitted that in view of the office memorandum in the relevant office memorandum in force and decision of this court in Achyut Ranjan Das. Get that citation for someone, huh? Achyut Ranjan Das, so and so, comma. It was permissible to reject the candidature of the petitioner on being time barred as a claim is not required to be considered after 2 years of being made. Next slide. As the state respondents have, the court is of the considered opinion that an opportunity be given to the petitioner to be acquainted to the disclosures made by the Deputy Commissioner, Sonitpur District, on production of such records. No, which appears from the on production of the said records. First, accordingly, the petitioner is put to notice that his candidature was previously rejected on by the DLC in its meetings held on 5/8/2014 and 21/3/2015. And that once again, the candidature of the petitioner was rejected on 24/1/2022.
Right,
The relevant counsel for the petitioner shall take appropriate instructions. The matter shall again be taken up after 2 weeks. You see, Mr. Sagar, the difficulties. If I accept the records and then dismiss it, he will not be put to notice. Why you don't file affidavits, I don't know. You see, I feel troubled. This matter is pending for from when?
2022.
2022. After 2 years, Mr. Sarkar comes to know that his candidature was rejected. That could have been done in the first day itself.
Probably that notification.
No, whatever it is, but don't ask the citizens to wait just to get the information that his candidature is rejected. People will lose faith on their officers. Why would the deputy commissioner not inform you? Why would it take 2 years to get that information?
Twenty-four.
Is it 3 weeks time maybe granted for filing affidavit
Uh,
for responding?
Mr. N.H. Borvial and Counsel, the petitioner, and Mr. S. Buyal and standing counsel for the Higher Education Department. Next para. It is notice that pursuant to order dated 22/9/2022 passed by this court, comma, the registrar vigilance had caused an inquiry and a report submitted by submitted the report has been submitted on 27/9/2022. It appears from the inquiry report that when notices were served, sorry, advance copy of this petition was served on the standing counsel for the Higher Education Department, comma, the person of whom the notice was served was not informed that the matter would be taken up as a listed matter. So the records indicate that the report indicates that as per the practice followed by the Education Department, comma, advance copy of the petition is required to be served on the learned counsel of for the department in the court and are not accepted in the office. Full stop. According to the said report is accepted, made part of the record. Next para. You want time?
I agree with us.
The learned standing counsel for the Higher Education Department pays for is granted. How much time?
3 weeks less.
3 weeks time to file affidavit in opposition in the matter. Full stop. Here is allowed. Full stop. It will be mentioned that by order dated 23/9/2022, this court had observed that the appointment of the persons as per the impugned select list is made subject to outcome of the petition. First of all, the Higher Education Department shall take note of the said observations contained in the order dated 23/9/2022. First of all. The respondents shall ensure that their affidavits are filed within time, this after 3 weeks. This inquiry report put in last.
Yes,
Yes, Mr. Babu, yeah.
My lord, this matter regarding compassion is down, my lord. Lord, I filed the petition, my lord, and it was, my lord, informed by the learned counsel from the government side, my lord, that earlier, my lord, my application once, my lord, rejected, my lord. Therefore, I have challenged this one, my lord. This is page 23, my lord.
Page
Page 23, my lord.
23.
Yes, my lord. It was rejected, my lord, on 30/11/2012, my lord. I have quoted, my lord. This is serial number 32, my lord. He was rejected due to, my lord, less qualification. My lord, your lordship also passed order, my lord, due to less qualification directly they cannot reject because I may be eligible for, my lord, grade 4, my lord. But as I am not qualified for teacher post, my lord.
But you see, even after that, after 11 years, we are not considering.
No,
it.
my
If
lord,
the rejection is,
my lord, this is the case, my lord. Lordship kindly will look. They, Somoto, my lord, they considered page 48, my lord. Again, my lord. Page 48. Here, my lord, they are differently, my lord, rejected. Page 48, my lord, last part. They said that, my lord, that, my lord, he did not submit next of kin certificate, my lord. But, my lord, here, lordship, earlier rejected 2012, my lord, that kin certificate was submitted, and I have also annexed, my lord, this, my lord, form they placed before the DLC page 20, my lord. Here, my lord, the next of kin certificate column is yes, my lord. Page 20, my lord. Serial number 8, my lord. Item next of kin certificate was there, my lord. And my lord, I have also annexed, my lord, my both the next of kin certificate, my lord, original one and duplicate one also, my lord. After losing the first one, my lord, page 15, my lord, this
you have to
was
send it back again. Even page 20, his next of kin certificate was there.
No, my lord, there is a problem, my lord. Initially, my lord, case of the petitioner was placed on 30/11/2012, my lord. That time rejected, my lord, due to less qualification. That, my lord, DLC, my lord, they have challenged. We filed an affidavit by saying that on the on 5/10/2021, we again considered the petitioner, application of the petitioner due to non-availability of the next of kin certificate that has rejected. On the basis of that instruction, my lord, we have filed affidavit. The petitioner withdrew the case, my lord. Withdraw the case.
So
The
now
court
he's
has observed
challenging
that if any new ground will come, my lord, they can file it, my lord.
Now he is challenging it.
My lord. And interestingly, my lord, then next to kin, first next to kin, which he has claimed, my lord, that is only for the purpose of the pensionary benefit, my lord, not for the other purpose, my lord.
No, you see,
Subsequently,
if
that-
somebody has a next of kin certificate, please tell us from your notifications
My lord.
that you issue next of kin certificates for different purposes. For compassionate appointment, you issue another next of kin certificate. For pension, you use another kin of next of kin certificate. For land mutation, you issue a different next of kin certificate.
My
That
lord.
is your submission. You produce us notifications of the government.
My lord, that notification part, I have to obtain instruction from the
No, but the
department.
deputy commissioner can't issue his own
Apart from the
notification.
notification, my lord, in the PRC case, my lord, they are two options, my lord. One PRC for the domestic purpose and other for the economic purpose, my lord. There is a specific purpose.
No, I'm not asking you for that PRC.
My lord,
Here it is next of kin certificate.
my lord.
Next of kin certificate, if you have categorized it, there will be a government notification to that effect. You see, I need a next of kin certificate for purpose 1. I write in the application I need for this purpose. Please give it to me. Second day, I am told that I need a next of kin certificate for purpose B. Should I apply again?
My lord, in case of succession certificate also that provision is there, my lord. Succession for a specific amount, my lord, applicant can apply that this amount.
No,
I
next of
already
kin certificate,
that this is
please don't
already-
confuse,
My
please
lord.
don't confuse that proposition. You see, you are saying about succession,
My lord.
correct? If in a succession, you want to add something more, you pay ad valorem court fee on the entire amount, correct? So please don't confuse it. If you are asking for a, say today, somebody has died. He found 1,000 rupees fixed deposit made by his father. He applies for 1,000 rupees. Tomorrow he finds that he has his father left 10,000 rupees more. He wants to get an extension of that succession certificate for the amount of 10,000 more. He pays ad valorem on 11,000 rupees. Please always keep that in mind. In succession and succession, there is always an ad valorem used. It's not a fixed court fee. So on the basis of in probate, if you want to have something extended, you pay additional court fee, not only for that purpose. It's an ad valorem addition. So don't keep that in mind. If that is in your mind, then you are wrong. But the question is that if you are a succession certificate, next of kin certificate, you give it for debts and securities under the revenue circular for an amount of rupees 2,500 only. You don't have under the general circulars provision where you can issue next of kin certificates for various purposes, only for debts and securities not exceeding rupees 2,500. They are not remember it because these things I have read when I was briefless. I don't know with so much matters I remember it or not.
Another thing, page 20.
You've seen the general circulars book. We may not have it in the court. You've seen a circulars of general certificate. The next of kin certificates are mentioned. No, not this. That's the comparison of land revenue or Assam land revenue regulation.
Kindly able to page 20, my lord. This is their own, my lord, form, where, my lord, this is regarding compassionate appointment, my lord. And there, my lord, it is noted that, my lord, there is a.
Page 20, it is yes.
Yes, my lord.
If in some other book, if in some other consideration, you find it no. Then it is for you to lodge an FIR. Somebody in your office has removed it. A document which is there in page 20.
Page 20, my lord. Yes, my lord, the serial number 8 item, next of kin.
It can't vanish.
Yes.
Certificate this year. They took me to the valid for that purpose and pension availability. Today, they take this to that, they reject the subsequently reject for a person which will become a in the meantime, this was the example of the book, and I have reviewed the was and all that. Which would have popular than
So revenue circulars are not there. It's in the comparison of general circulars. You'll find a circular of next of kin certificate. And I'm sure, although I may not be able to locate it now, but it is for debts and securities not exceeding rupees 2,500. And that has never been amended. So we'll issue a direction to the deputy commissioner. to Examine both of these. How can this both be sustainable? Yes, you can see this. This is from your citizen portal, correct?
My lord.
You see the form, it doesn't say for what purpose. Merely it says next of kin certificate. You can go back and find that it's from that citizen centric certificates, what you call service portal. So merely when I am applying a right of purpose, and this next of kin certificate
My lord.
is required to be issued free of cost. Although if you go to the deputy commissioner office, you cannot come out free of cost. In my statement, service charges are not included. So we send it back to you for re-examination, and if this is correct, page 20, then his candidature has to be placed before this next DLC.
The DLC will take decision as per the guidelines.
So you make that inquiry, page 20 inquiry you make, and if this is correct, then you're noting that the in the next last DLC that this was missing will be incorrect, and then we have to reconsider it.
No, they have not saying this. Saying that, my lord, original was there, my lord. That is, my lord, in the statement itself.
Where is that?
Petitioner pointed out, my lord.
Where is that? Which page you are referring?
Page number probably 20. Page number 20, my lord.
No, 20 I have seen.
My lord.
You are referring to which document?
Page number 20, my lord. Next to the certificate, my lord, marks was Y, my lord.
Yes.
That is noted, my lord.
No, your application which was rejected. Where is that, Mr.
Yeah,
Bhavya?
this is my lord, page 48, my lord.
Page 48. 48 says next of kin certificate not submitted.
Yes. Sir. But forum says my lord is submitted.
So your deputy commissioner will have to make an inquiry.
My lord.
And if this finding at this order dated 11/10/2021 is incorrect, he has to place it again,
My lord.
and it will not be rejected on being time barred.
My lord. That.
Mr. A.M. Barbunier and counsel for the petitioner, Mr. A.M. Barbunier and counsel for the petitioner, and Mr. P. Saikal and government advocate appearing for the respondent number. You have all the respondents,
No, my lord.
1 to 4. And Ms. Ann Pugan, then
My lord, I'm 2 and 4, my lord.
2 and 4, so 2 and 4.
I have for respondent 1,
and three, yes, and Pugan,
1, 3, and 5.
standing counsel for the school education department appearing for respondent numbers 1, 3, and 5. Next paragraph. The father of the petitioner died in harness on 10/8/2007. The claim of the petitioner for appointment on compassionate ground was initially rejected on 30/11/2012 on the ground that the petitioner is underqualified. Full stop. The petitioner had approached this court by filing WPC 6279 of 2014 to assume the rejection of his candidature. And this court no. You approach this court, where is that order?
He was not aware earlier rejection, therefore, my lord, subsequently again rejected page 48, my lord, and against that, my lord, I filed after page 48, my lord, page 49 writ petition, my lord.
Achha. No, the last line of this strikeout. The candidature of the petitioner was once again placed before the DLC. And by a letter dated 11/10/2021, the Deputy Commissioner and Chairman, District Level Committee Hailakandi issued an order whereby the candidature of the petitioner was rejected on the ground that the next of kin certificate was not submitted. Full stop.
Then page 49, my lord.
The petitioner is sealed
Then they informed my
no,
lord.
it's just a moment. You have a copy of that writ petition,
My
earlier
lord,
writ petition,
earlier writ petition, my lord,
then we'll call for.
yes, my lord, then I withdraw, my lord, this is the page.
No, that I've seen, but I've seen something more which, for which we require your earlier writ petition. You see, your submission now was that you were not aware of order dated 11/10/21,
No, Lord.
and therefore you filed the second writ petition.
No, Lord, 2012 was not aware.
No, that's okay. When you filed this writ petition, second writ petition,
Yes, sir.
you were aware of this order dated 11/10/21, correct?
First writ petition, my lord, lordship, kindly will look page 50, my lord. They informed my lord that earlier rejected, my lord, date is given, page 50, my lord.
No. If I've understood your submission correctly, you are now saying that when you approach this court by filing WPC 434 of 22,
Yes, my lord.
you were aware of the order of 11/10/21, right?
Yes, my lord.
Correct.
Correct, my lord.
Now you see this order at page 52.
Yes, my lord.
On instructions of the petitioner, Masuk Ahmed Borbuya, his counsel,
Yes,
namely Mr. S.B. Laskar,
Yes, my lord.
prays for withdrawal of this writ petition with liberty to file afresh
Yes,
as and when a new cause of action arises.
yes, my lord.
Now you are once again saying that you are challenging the rejection of
No.
your candidature by order dated 11/10/21
No,
on the ground that previously the document was there and now it is not there. So you are challenging the same cause of action. Your reputation will not be maintainable.
my lord, this is my lord, my lord, consequently, but because my lord, lordship can only page 50, my lord.
I've seen that.
Page 50, my lord, they inform my lord, but 21 is my lord meaningless because my lord, as I am already rejected in 2012, my lord. But in that year 2021, they could not have rejected my lord. Which is inconsequential, my lord.
No, whatever be. But here this order says, gives you liberty to challenge a new cause of action, not a past cause of action. So your reputation will be liable to be dismissed.
A new cause of action means, my lord, I have taken my lord liberty to file afresh, my lord,
New cause of action.
new cause of action, my lord, this 2012, my lord, my lord, my
No,
2021
cause of,
order.
Mr. Barbia, this cause of action is something that is ingrained in my mind. Correct. Since I've half my life dealt with cause of action only.
New
It
cause of
is-
action, my lord,
It is only that cause of action which has brought me here.
new cause of action, my lord, means, my lord, my understanding, my lord, then out of, my lord, that earlier repetition, my lord.
No, that is your understanding, may not be same understanding which
Because otherwise,
is
my
a
lord,
course.
remediless, because, my lord,
will be remediless, because now you'll have to challenge that withdrawal. You say that you come for a new cause of action.
even your lordship.
On the,
Yeah.
no.
Withdrawing the
Just I say,
repetition.
when you make me read, I read it completely.
Yes, my lord.
You make me read this order and then this order says new cause, old cause of action can't be there.
After withdrawal also, my lord, repetition, I have stated everything, my lord.
No, that may be there,
Even
but then
my
you
lord,
should not have withdrawn it then.
that proportionate, my lord, even my lord in uphold in my case, one of my case, my lord. My lord had dismissed that my petition, my lord, on that cause of action. my lord.
No, cause of action is something.
All these things, my lord, why I withdrew, my lord, and all the records before your lordship. Because they apprised that, my lord, page 50, my lord, that I am already rejected in the year 2012. So therefore, I have no other alternative but to withdraw, my lord. A new cause of action because, my lord, cause
Mr.
of
Das. Mr. Das. Respondent numbers 1, 3 and 5. Next para. That earlier will stand, huh? What you call, till last paragraph, what did they say? It's okay. Acha, okay. You just add there. The consequent upon the order dated 11/10/2021 passed by the Deputy Commissioner, Chairman DLC Hailakandi, the said order was challenged by the petitioner by filing WPC 434 of 2022. Full stop. It is projected that when the said writ petition was listed for hearing on 17/11/2022, the learned government advocate had produced instructions showing that the candidature of the petitioner was previously rejected in the DLC meeting held on 30/11/2012. And therefore, the learned counsel for the petitioner submits that on such disclosure, the petitioner withdrawn the writ petition.
page 52.
Writ petition with liberty to file afresh. Full stop. Next paragraph, it is submitted that on the earlier occasion, when the candidature of the petitioner was rejected in the DLC meeting held on 30/11/2012, the in the statement of particulars, comma, in respect of next to kin certificate, which is at column 8, comma, the remark of the authorities is Y. So it is submitted that Y would mean yes. So accordingly, it is submitted that the reason assigned in the order dated 11/10/2021 issued by the Deputy Commissioner that the next of kin certificate was not submitted along with the application is incorrect. First off, it is submitted that as per his understanding, comma, when he had made a prayer for allowing to withdraw the petition and to approach again, comma, as per his opinion, comma, the fact that the dismissal of candidature of the petitioner by order dated 11/10/2021 was on an incorrect premise was a good ground to challenge the said order. Next para. The order of the court dated 17/11/2022 passed in WBC 434 of 2022 reads as follows. This is page 52. Next para. Notwithstanding whatever the intention of the learned counsel was when the prayer was made to permit him to withdraw the writ petition, comma, this court, while granting that leave to withdraw, had provided that the petitioner had liberty to file afresh as and when a new cause of action arises. Full stop. Accordingly, comma, the court is of the considered opinion that when liberty was granted to approach the court on a new cause of action, comma, the same would not mean challenging the same notification, the same order dated 11/10/2021 on a different ground. First off,
My lord, my prayer, my lord, page 12, my lord. I mainly, my lord, challenge in this case, my lord, minutes of 30/11/2012, my, this is my first prayer.
it's okay.
Because it is, in view of this, not, my lord, minute prayer.
I'll take note of that. Don't worry. I just have 2 minutes, then I leave. I'll complete the orders in the chamber. Next paragraph. The learned counsel for the petitioner also submits that one of the prayer made in this petition is to challenge the rejection of the candidature of the petitioner for appointment on compassionate ground, which was taken in the DLC meeting held on 30/11/2012. Then this prior to that observation come now. Huh? In the further opinion of the court, comma, if the challenge to the order dated 11/10/2021 was withdrawn, comma, the qualification made in the order dated, the qualified order dated 17/11/2022 would prevent this court to entertain the challenge, comma, if any, made to order dated 11/10/2021. Full stop. This situation leads the petitioner to to a trap. And it would prevent the petitioner from maintaining a challenge to the decision of the DLC taken on 30/11/2012. The reasons are twofold. First off, firstly, even if the challenge could otherwise be made of the DLC minutes dated 30/11/2012, the rejection of the candidature of the petitioner by order dated 11/10/2021, even if for incorrect reasons, would still stand, as it would not be as challenge to the same cannot be maintainable in view of order dated 17/11/2022. First off. Secondly, the order of compassionate appointment is to enable the concerned candidate to overcome the period of crisis. First stop. In the present case in hand, the father of the petitioner had died in harness on 10/8/2007. First stop. Therefore, as on date, how many years would go by? 20?
About 15.
15 years. Okay, about 15 years has gone by. And therefore, the immediate necessity of the petition has passed over. Full stop.
I will come, my lord, by modification or that liberty may be given at this stage, because my lord, now going
But
other.
now you see, now you lose that opportunity also because of my observation, which I am now making.
My lord, because my lord, your lordship is.
Because I told you, I give you a fair warning. I told you that I have reasons and I'll put it in the orders.
That, my lord, so far, I have, my lord, from now, my lord, bar, my lord, page 52, my lord. So, my lord, that liberty, if it is modified.
You can't get that order. Because then it would mean that if I am sitting in appeal over this.
I will file my lord review, my lord, because your lordship is aware, my lord, this is
You
just mistake, my lord,
I got nothing to say.
how, my lord, I will withdraw this petition, because with a bona fide belief that, my lord, I will filing this petition again, my lord, 2012, my
No, I
lord.
understand, but you see, what can I do? This order of this.
Everything before your lordship.
No, you
Because
see.
the writ petition filed, my lord.
No, that is
against my
okay, but you
grievance.
see. You see, the problem is that we are dealing with a legal issue. It's not an emotion which can override. You see.
Fact remains same, my lord.
No,
because-
fact not even same. I'm certain I have a constraint of time. Just tell me one thing. You see, can I sit in appeal over order dated 17/11/22?
Definitely not, my lord. So therefore, this
Then-
is my bar, my lord. So my lord, I may be allowed to modify, then I may approve, my lord, because this is my lord, my bar, my lord. So far, this other stance your lordship is considering, I cannot file this writ petition, because there is some, my lord, wording is there. So, my lord, with this observation, my lord, if I can modify, then I'll file writ petition, my lord. I'll file review petition, my lord, tomorrow. Monday, my lord. Because I would do, my lordship is aware, my lord, because I standing writ petition would do with the hope that, my lord, I will file this writ petition. But in the meantime, some wording, new cause of action, and my lord, I thought, my lord, the new cause of action, my learned friend, my lord, they give, my lord, instruction, it was rejected. This is the new cause of action. If necessary, my lord, I try to, with my lord, review petition.
So don't write all these things. Just write the names and say that after some deliberation, Mr. A.M. Burmiel and counsel for the petitioner seeks to withdraw this writ petition. Prayer is a lot. My question is dismissed on withdrawal. I will not make that observation because that would create a difficulty. This-
Then I will not file, will to file it.
No, you are filing a review under that. That will not be a bar.
My lord, you want to, my lord, file review petition against this order, that observation may be given. Because he wants to, my lord,
Oh, okay.
file review petition
So-
against this order.
Okay, to file a review petition against order dated 17. What is that order? Give the date.
Yeah, for page 52, my lord. I'm withdrawing to file review against this order.
Oh, okay, so I'm going to file a review petition against order 17/11/2022 passed in WBC 434 of 2022. I'll have to rise. Any request, please make to the court master. If there is an interim order to be extended, please.
Item number 30 lawsuit from urgency on the state of Assam is there also. Lawsuit in the next
Just tell him,
witness the lawsuit.
just tell him. I have a meeting, I can't postpone that.